edition of the International Conference Perspectives of European Business Law. It's both an honor and a privilege to stand before you today as we gather here in this new building of Bucharest University of Economic Studies for this scientific event. As we embark on this journey over the next hours, we find ourselves united by a common purpose: to share knowledge, to foster collaboration, and to discuss about new legislative perspectives in European business law. This year's edition invites us to explore new horizons and discover together solutions that can make a meaningful difference in our field of activity. We are thrilled to welcome participants from different universities and countries, different areas of research, but united in one goal: their interest on European Union law. This multi- and transdisciplinary perspective is what makes our conference special. Throughout this conference, we will have the opportunity to engage with experienced professors and pioneering researchers through keynote speeches, panel discussions, and interactive debates. I encourage you to immerse yourself in the sessions, ask questions, and network with your peers. Each conversation could spark new ideas, partnerships, and pathways towards innovation solutions. Today, I am one of the hosts, so I will be speaking on behalf of the Center of European Business Law Studies, a research unit within the Faculty of Law. Today, in the conference, we will host a special event, the launching of the Research Center, and I hope you remain with us to celebrate this moment and to find out more about this center. Now, I would like to give the floor to Professor Edil Work, the Dean of the Faculty of Law and the main host of this event. 2 years ago, his efforts made it possible to establish an international conference focused on European business law, and today we celebrate the 3rd edition. This year we have the first master's program in European business law, and today we are launching at the faculty the Center of European Business Law Studies. Professor, we thank you for your efforts and your continuous effort.
Dear Professor Patrick Sandsburg, dear colleague Andreas Tăncescu, esteemed guests, dear students, because we have also students in the room, welcome for the 3rd edition of Perspectives of Business Law, a conference, as Andreas said, that we started several years ago as part of a project, a bigger project that we have in our faculty, the one that has different components: teaching, research, students' research, and even extracurricular activities. This idea of entering the field of European law on the aspects of business law is not new in us, because European law, business law are two of the main subjects in our syllabus, and they have been for the last 20 years and more. So especially after Bologna, when we had to switch from 4 years to 3 years, business law became the main subject in first year of studies of our future economists, managers, accountants, and tax consultants and others. And in time, of course, because we are teaching also European law as a specialized subject at certain faculties, we designed this new subject, European business law, trying to get a bit through the institutional part, but also to the material part, especially to the single market. And as this was our work as teachers in this university, I think it's normal to be the first field that we developed in the research area. So we started with a conference, we started 1 year ago designing a new master, as you Andrea indicated, and now we have the first generation at the master degree European Business Law. Now we are launching today the first research center of our faculty, which is in the same field. It's called the Center of European Business Law Studies. Also today, we have another launch, let's say. We have the ceremony awarding the best prizes for the best papers of students' research. And also, I have to point out, also today as a teaser, anyway, we are not launching anything, but we're letting the public know that we'll have also business law talks, especially with foreign guests, either online or by inviting them in Romania and having them in a studio. So, so many projects in the same field, a field that, as I said, we have developed in the past 20 years, and especially from the moment we started this faculty. It's a young faculty. I suppose everybody in the room knows this. And we tried in this 5 years, I say, because it's also the work the year before the creation of the faculty that some of us were involved in. In order to offer, to answer to a need and to offer to the market lawyers, journalists, jurists with certain special competencies. And I think that business law is addressed not only to non-lawyers, but also to the lawyers who want to, no matter they decide to go to the magistrate school or the bar, or just to be in-house lawyers in companies, to have these special competencies that we design here, and we hope that in time we can actually transfer to our students. As you all well know, we have the first generation, so we already have lawyers, junior for the moment. We hope we'll have the first magistrates, and we, the teachers, me, the dean, and my team, we hope that they will actually use these competences and they will become renowned lawyers in their fields. We try, and I think we have been trying for the last years, to adapt our syllabus and our projects, teaching one, researching one, and of course even extracurricular one, to all these needs that we identify in the market. As regarding the conference, I am staying here with Professor Sensburg, who was online at the first edition, but he's not that new to our faculty and our university, because he has been teaching for the last years in different levels of study. We started at master degree, at European law, European contract law, also international business law this week. So different subjects at the master degree, but some years ago we decided, even if it's a little bit more complicated than bachelor, because over there we don't have a module style education, we started collaborating also at European Union Law Bachelor Studies. And if I'm not wrong, Patrick, you started teaching, I think the first year was 2016, so we are closing down on having a collaboration of 10 years. And I want to thank you for this. Patrick, as I know, of course, at least in the era of our department and faculty, was the first visiting professor at law. I'm pretty sure others maybe came in immobility, but with a new structure, I think you were the first. And I want to thank you for this, for backing up the team in all the projects that we had in this area of European business law, and especially me when I came with the ideas. Patrick was the one coming with other ideas and also helping me understanding better certain fields of European law, and especially how we should manage both the teaching activity but also the research, and the conference is the main project in this field. As you may know, if not you noticed, this conference started in a hybrid way, so everything that happens here is broadcasted. We continued. Some of the conferences we ended because of the lack of persons in the room. Everybody got used during the pandemic and after to still online to watch. We received messages, how can I watch this online? Yes, we were there. We were forced to go there. We have a YouTube channel. We are broadcasting by our social media, especially Facebook page. But in other conferences, because of the lack of networking that you normally have during the conference, we decided not to broadcast anymore. Well, with this conference, because we have friends abroad and we were asked to pursue this, we'll have it also online. I know how it will be in the future, but I hope that we'll keep this because I consider it's important for the ones in Bucharest and other cities, but also in Europe and other states to be able to watch this, to connect with us. We're going to answer from time to time. We're going to transfer the questions to the moderators, the questions that we receive by the YouTube, especially channel. And I hope in this way that we'll still use the positive that comes from the pandemic, meaning this online communication and online broadcasting of this. The podcast, Business Law Talks, is also another instrument that we'll try to use the advantage of technology in the end. But it's very important to have persons here, not as much as for the communication and debate area, but more for the networking that during the breaks we'll have. We'll have several breaks. The main one is at lunch, but I'm asking all of you here present to be there because it's not just a lunch, it's a lunch with a special event, which, like Andrea said, is not special only for us, but for us also, for our university. The launch of the first research center of the Faculty of Law here in ASE. And after the lunch, we'll have also the awarding of prizes for our students who competed in this interesting competition perspectives of European business law. I want to thank Andrea for the activity that happened in the last weeks and also for taking over, accepting my invitation to take over this, I consider very complex and very complicated job as director of the research center. I want to thank Patrick for being next to us here, giving us in time ideas and also support in our projects related to European law, and also even extra to European law to others related to teaching generally. My colleagues from the Dean's Office, two of them present here, Vice Dean Dreptul Afacerilor and Vice Dean Anul School, research and teaching. And also the other colleagues I see in the room, some PhD students I see in the room as research assistants. And in the end, especially the guests who came from other cities, other universities. For us as a young faculty, means a lot to have support to see that actually our events are appreciated by the colleagues in the field. We are young, and the years as youngsters, the stimulus team is very important and will give us actually the energy to continue with these projects. Otherwise, from time to time, anxiety of the intervenes and you may actually give up something because you don't realize that is really appreciated. So your words, kind words, and your support and your presence here, it means a lot for us. Thank you all, and I think I'll switch back to Andrea as moderator of this first opening session. Thank you.
Now I would like to invite our guest, Professor Patrick Sensborg, Professor of European Union Law at the University of Applied Science for Police and Public Administration in North Rhine-Westphalia, for a welcoming speech. And afterwards we will begin with our first session with institutional EU law that will be moderated by senior lecturer Laura Spătaru-Necura from Nicola de Luca University.
Thank you very much. Thank you very much for the nice and warm introduction. Yes, it's right. Since 2016 I'm already here. teaching in different courses. And that also means that we have such a good collaboration, that we have such a good cooperation, and it shows that the path to a law faculty was already built in the early years, and it's good that we have the law faculty and we have the Center of European Business Law Studies here opening today. So I'm very pleased to be here today and to speak a warm welcome as well, because you couldn't choose a better time for your third edition of the conference. The new president, or it's already not the new president, but the re-elected president of the Commission is in power. You followed, I think, the hearings in the European Parliament of the commissioners. So we are really in a situation where the EU Commission takes step by step again over its duties and comes into power. And we are in a time where the world is changing. We have an epoch-defined situation in our days now, where Europe is struggling about its position in the world. So we see that new powers are rising. I don't have to talk about the US after the elections. I don't have to talk about China. I don't have to talk about India. You can see all the power poles in the globe are changing and will be defined new. And which role is playing Europe? Which role is the EU playing? So in this time, to host such a conference is smart, it's good, and it's best to have a wide, opened field of discussion concentrated on business law. Of course, business law is crucial for all targets of the European Union and the new EU Commission, because without a running market of 27 and even more countries, all the targets, all the aims, everything that the EU stands for is not working. Many years ago, the EU had the target to be the strongest business area of the world. It's nearly forgotten, this target of the Commission. But how can such a target be followed, or such a target be on the headline, if we don't have a strong internal market? If we don't get closer and closer together with our laws? How can we arrange all this, and how can we make it possible that the European Union is the peace model for the world, especially for us, of course, on the European continent, if business, if wealth, if economic growth is not working? So, to have a clear perspective, of course, for the whole European Union, but especially for European business law, and to have the contact between lawmakers, scientists, politicians, and experts, it's very important to host such a conference. I'm very pleased that we have not just you here as the audience in the conference hall, but also to have the chance to broadcast this, because not just your friends, your collaborators, all the people you know are here, my students will be here as well. So they don't have me in the courses this week, in the second half of the week, but I could share the Facebook and the YouTube link with them. So it's good to have a hybrid conference, and I really hope also my students will watch this conference, because it's very good to have a good teaching staff at a faculty, without doubt. But it's also good to be continuously on the top of research and to have the discussions, because teaching without research is in the end, on the long run, not possible. And research without teaching is a lack of reflection. So in the end, to have both in the faculty, it's very good. And to open to EU partners, to open internationally, that's the way a faculty should do it, and you're doing it here best. So a warm welcome from my side to all participants of the conference. Of course, to all speakers. You arranged a wonderful program, from my point of view, to all interesting parts of European business law, again, on this third conference, and I'm very curious to hear all the speakers, to follow the discussions, and in the end, to see some results that this conference is again pushing issues forward, because I know, and I was 12 years member of the Parliament, I was 8 years chair of the European Law Committee in Germany, I know that these conferences are reflected and noticed also on the lawmaker side, on the politician side. So I wish this conference a very good time, good discussions, and also an impact in politics. Thank you very much. Thank you.
I think we have to invite the moderators. Patrick, stay here. Thank you, Patrick.
Thank you.
Professor Predescu, would you like?
Good morning, everybody. It is a very great honor to be here. Thank you for inviting us. Thank you, Ovidiu. Thank you, Andrea, for organizing this wonderful conference. It would be difficult now to start to present our keynote speaker because already Ovidiu and Andrea both, they already discussed. When I first found out about the keynote speaker of this conference, I said, okay, Ovidiu just wrote something on Facebook, and I researched a little bit, and I was so amazed because this is like the background that I would like to have politicians in Romania. Because when you are a politician, you should also have information and very strong knowledge of European law and public law. And of course, in this period of time, I think it's very important to discuss about the European Business Code. And I give you, Professor, the floor. The floor is yours in order to present us what are the latest discussions regarding this topic, this hot potato, if I can say like this.
Yeah, you're quite right. It's a hot potato. And what are you doing with hot potatoes? You're handing it over very fast to others, but someday you should make something out of a potato.
Of course.
It's not a ball, and it's not a sports game. So in the end, out of a hot potato could come a wonderful dish. And let's see if we make a wonderful dish out of this hot potato. The title of my little impulse, I would say, is the European Business Code and the program of the new EU Commission, Europe's Choice, 2024 to 2029. Of course, I put the issue in the context of the new Commission's agenda. Of course, just to do some introduction words, of course there is a little will, a wish behind this title, that the new Commission is pushing this issue forward because I think it's really important issue for the European Union. So that's how this title was created. On one hand, the draft, where are we? And on the other hand, the connection between the working program of the new Commission. I'm very eager to look in the working programs of the Commission because the Commission regularly, since in the past, had very precise and very well written programs. Not all commissions did. Some commissions did said we're just doing the leftovers of the last 5 years of the Commission. So new we have a working program of Mrs. von der Leyen in the second period, and we all have to make enough pressure that in this working program, Europe's Choice, we will find enough of the issue of a European Business Code. So after an informal and a formal meeting of the EU heads in state in June and a consistent plenary setting of the Parliament in July, on Thursday, 18th of July, Ursula von der Leyen was re-elected for a second term as the President of the European Commission with 401 votes in favor and 284 against her. So it's a majority, but she has to convince a few in the end. On that occasion, the candidate released her new political guidelines for the Commission in the years 2024 to 2029, presenting the strategic plan for the next 5 years. Because of the modified and fractured political landscape, von der Leyen needs to balance the demands of the right-leaning parliament with continuing to push forward key initiatives like the Green Deal, and the document presents her manifestation of this effort. The guidelines entitled Europe's Choice, I think it's a very good title because the choice is where are we going? Will we be a leading region in the world with our values, or will we just let go? One sentence I heard many years ago, somebody said Europe played a role on this globe round about 1,000 years. We were in the history books. Before that, there were others, and from now on there will be others again. So The question is Europe's choice. Where are we going? Do we try to play a role, a strategic role on the globe with our values, or are we vanishing away? So this program, Europe's Choice, articulate in 7 chapters the priorities of the upcoming Commission. First chapter, a new plan for Europe's sustainable prosperity and competitiveness. Second, a new era for European defense and security. Third, supporting people, strengthening our societies and our social model. Fourth, sustaining our quality of life, food security, water, and nature. Fifth chapter is about protecting our democracy, upholding our values. 6, a global Europe, leveraging our power and partnership. And 7th chapter is about delivering together and preparing our union for the future. The first and most important chapter focuses on the competitiveness of the European Union, stating the need for a new European perspective plan to make business easier, reducing administrative burdens and simplifying implementations, deepening the single market, build a clean industrial deal to decarbonize and bring down energy prices and create a more circular and resilient economy. It also stresses the importance of boosting productivity in digital tech, diffusion and investing massively in sustainable competitiveness, unlocking the finance needed for the green, digital and social transition. As President von der Leyen puts it, Europe cannot afford to fail behind and lose its competitiveness edge in this global race, nor can it leave any strategic vulnerabilities exposed. The other chapters of the guidelines cover the urgency for an enhanced European defense and security plan. Of course, that's in the news every day. I don't touch this in the next minutes. A renewed attention to democracy and social fairness, with a special focus on supporting young people. That is also one really epoch-defining challenge, the age of our societies and how it will develop in the next years. The necessity to maintain our quality of life, including food security, water and nature protection, and a new strategy to leverage EU power and global partnerships worldwide. Our role on the globe. As in these past 5 years, Europe has set course on an ambitious program of modernization. The focus must now be on implementation, investment and reform. For this reason, the final chapter emphasizes the intention to have a modern and reinforced long-term EU budget fit to achieve the ambitions set out. So that's the guidelines in general. And you already noticed that there's an entree in the first chapter for the business law. The guidelines can be seen as a wide call for strength and unity, as Europe is challenged by generational threats that cannot be overcome without joint action. A strong economy and a reduction of bureaucracy are the key factors to achieve these goals. For a deeper integration in European business law code has been discussed since a while, especially since the Commission's own white paper on the future of Europe. Contrary to example for EU sales law, with the European Business Code is developing step by step. Many of you have followed the discussion of European contract law, European sales law, the hearings, the subsidiarity questions on this draft. With European Business Code, we still don't have this fear of the member states that the EU is going in subsidiarity areas, and we don't have this broad discussion with also negative aspects coming from the member states. So the European Business Code is one project in the first chapter, a new plan for Europe's sustainable prosperity and competitiveness. Without a European Business Code, no full competitiveness could be the headline on the Commission's plan. So, why a European Business Code? After the white paper from 2017, Germany and France in 2019 signed a treaty to integrate their economies into a Franco-German economic area and to harmonize their laws inter alia in the area of business law. Rather than seeing this as a counter project to the European Business Code, both countries intend to be the first step, to be the engines, to be the countries who are pushing things forward, but of course open to the whole European Union. Also, in the citizens' consultation on Europe, mobilized civil society in various member states of the European Union, and not just civil society, of course, the business part in the civil society. These consultations notably helped highlight real expectations on the part of both citizens and socio-economic stakeholders, especially SMEs, small and middle large enterprises, but also the business representatives in general regretted the lack of harmonization in European business code. Various articles, research papers, books pointed out already why a European business code has a huge economic benefit for the market and even further. I don't refer to all these arguments today, pro-European business code and just a few contra-European business code. But I just want to mention here that the Commission points out its general argument that a EU-wide unified code is by itself a benefit for the economy and for business. That's what the Commission always does. A unified code is a benefit. But there is much more behind this argumentation compared to other drafts of the Commission. We can't go to all these arguments, but if you follow the discussion and if you compare it with discussions of previous drafts, you can see here's much more pro and much less, especially concerning subsidiarity issues, than in other drafts before. As in other cases, like the EU sales law, academics like the Jacques Delors Institute or the Henri Captain Association or Association have undertaken a great deal of work on the first stages up to a draft that is discussed widely now. So it's a very, very good practice in the European Union that the first draft is not 100% designed by Commission, by experts in the administrative sector. It's open to academics. Academics make the first draft, and then we have a level playing field, I could say, where we discuss the draft before it comes in the political arena, and there, of course, changes are made, but we have a profound draft, and that's what we have. The actual draft of a business, a European business code made by academics, by experts, by people who are working on this field every day. The implementation of European Code of Business Law is one of the key recommendations of the report, much more than a market, authored by Enrico Letta, president of the Jacques Delors Institute and former Italian Prime Minister, to strengthen the European single market. I really suggest you to read this report. It goes much further than the European Business Law Code. It really is an eye-opener for the problems of the European Union if we want to go further with a single market. And he puts really, points the problems of the European Union and also gives solutions. So this is a remarkable report that everybody should look inside. It is a promising development that the newly re-elected president of the Commission has included Mr. Letta's report suggestions in her roadmap. So that's why I mentioned the report. It is in the roadmap of the Commission, and in the section that is called Facilitating Business Activity, there the advices of the Letta report are included. She has further expanded on these suggestions by introducing the concept of codification already in her first days of the second period, you can say, and I quote, "On this basis, we will make proposals to simplify, consolidate, and codify legislation to eliminate any overlaps and contradictions while maintaining high standards. We will also address the patchwork of national regulations that makes going business in different EU countries more complicated. We will make it easier for investors to succeed by reducing the costs of failure. To support this, I will propose a new EU-wide legal status to help innovative companies grow. This will take the form of a so-called 28th regime to allow companies to benefit from a simpler, harmonized set of rules in certain areas. So, again, a 28th regime that we already know from other drafts, not a regulation that overlays the national law. It's an option that stands aside, but of course in the long run will influence the national law totally. With the scientific support of the Henri Capitan Association and the support of numerous European foundations, the objectives of the European Business Code project is to address, whenever feasible, the fragmentation of European commercial legislation. This fragmentation hinders the ability of small and medium-sized enterprises to thrive within the internal European market, thus affecting the economic competitiveness of the Union. In his report, Enrico Letta demonstrates that it is possible to make useful progress within the framework of a 28th optional regime with the creation of instruments such as unique status for European SMEs, the simplified European company, the Eurobond, the Euro guarantee, the Euro security, the European loan contract, and the European insurance contract. All are examples that are in the Letta report. Those tools are essential for any business wanting to make full advantage of the European single market. They will also promote realization of the savings and the investments union, capital market union, which will enable innovative European companies to secure the necessary financing with Europe instead of having to relocate to the currently more competitive American market. If you are a highly risked enterprise, new on the market, capital is easier to get in US than in the European Union. And that is a problem for development and innovation. On 18th April 2024, so it felt like yesterday, Enrico Letta presented his much-awaited and above already mentioned report on the future of the single market, much more than a market. In it, he warns the EU is lagging behind other markets. In its economy of the European Union, it's growing at a slower pace and it is less competitive. He notes that over the past 30 years, the GDP per capita has increased by almost 60% in the US as compared to the European Union, just 30%. In observation echoed in Le Monde, they titled, "Latest forecasts from Brussels confirm EU failing to keep up." So we are behind. It identifies a number of reasons for this, pointing in particular to the daunting complexity of the fragmented market landscape within the European Union. Cultivating a single market in which European business can thrive has become an economic and strategic imperative and is essential for EU's sovereignty. So you can understand now why European business law and the European Business Code is so crucial for the strategy of the new Commission. With this in mind, Letta backs the Association Henri Capitan's proposal, supported by the Fondation pour le droit continental for a European Code of Business Law. They are the creators, the authors. A European Code of Business Law would be a transformative step towards a more unified single market, providing business with the 28th regime to operate within the single market. It would directly address the current patchwork of national regulations, acting as a key to unlock a full potential of free movement within the EU, writes Letta in his report. The report draws in particular on the 2024 Single Market Survey conducted by Eurochambers, an association, as you all know, of European Chambers of Commerce and Industry. Among the business owners and entrepreneurs surveyed, 68% cited the different constructual or legal practice within the single market as an important obstacle to trade. So also the ones who are working every day in this field said we have a problem there, to make it simple. Despite 19 member states having successfully adopted a single currency, harmonizing European business law remains an ongoing challenge, which desperate national legislation is still continuing the primary source of law in this area. and of course in all kind of elections, you have election in Germany, we have elections in many countries too. This year is the election year of the whole world. By the way, business law and issues in that field are in all kind of election campaign issues, so it's still a national issue as it's felt, but it should be European. All too often, this leads to competing laws within the EU, within the Union, the opposite of what is needed to support a unified trade area with the critical mass to hold its own against other major global markets. To make it clear, we will just play a global strategic, political and economic role on the globe with actors like, as I already pointed out, US, China, India. An outstanding and real single market is necessary. It's the overall key factor for the whole future of Europe. Basis of the European Business Code is the first working vision of the work constituting each of 13 books, making this code the state of simple preliminary draft in a perfectly provisioned version, and this for the sole purpose of participatory discussion and improvement. So we have a work of experts that wrote down 13 books, I will tell you in a few seconds, and as a discussion draft, so a wonderful work that gives us a chance now to make the political decisions. We have the draft of experts on the table. Now it's the task of the lawmakers to bring it into power. The draft of the European Business Code is intended to promote the European Union by highlighting the codification that so many countries share, while promoting economic growth in the area and the competition of the common market. In this regard, the introduction of the European contractual instruments could be make a notable step forward. With the new commissions in power, soon the time has come to go into the details of the current state of the work of the 13 working groups. Until now, and since quite a while, the 13 books, which are the product of the 13 working groups, are preliminary drafts that intend to illustrate by written proposals and not by simple reports. So it's the written draft of a code and not just a report that shows problems, shows chances. So it shows the fundamental interest that the adoption of such a code would present in the long term. The 13 books are Book 1, General Commercial Law, Book 2, Market Law, Book 3, Electronic Commerce Law, Book 4, Company Law, Book 5, Security Law, Book 6, Enforcement Law, Book 7, Insolvency Law, Book 8, Banking Law, Book 9, Financial Market Law, Book 10, Intellectual Property Law, Book 11, Labor Law, Book 12, Insurance Contract Law, and Book 13, Tax Law. I have them all with me. But we won't go through every book now and discuss the articles, the paragraphs. That's not possible. But they're easy to access. So if you want to look in the book that's related to your work, go inside, go in the internet. The drafts are there, open for discussion. So the whole work in 13 books is open for discussion, for an academic discussion, what we do today, but also for a political discussion on the agenda of the EU level and of the national parliament level. Its acquis was collected and structured. In doing so, common principles were put in brackets. In a general part, there we have, of course, as it's the word it says, a general part that we can reflect in all parts following. The authors have slimmed down the standards, which sounds a little bit strange, and presented them in a special section in the following 12 books. Slimmed down the standard means, of course, they recognize the national standards. We want to codify the common issues. Their sorting, it's similar to a little bit when you look to the German and also partly to the Romanian civil code. There are a lot of similarities, by the way, if you look inside, and that could make our two countries a little bit happy. French, they are inside, they delivered it, but it's more connected to our codes, of course, to the Code Napoleon as well, but in the end, a lot of influence come from other countries as well. So, consequently, it ends with the book Insolvency and Reorganization Law. It's not the 13th book, it's from the first part, the book, and includes also this part, let me say it in my words, who risk a business can also fail. This is not a disaster if we don't have people to risk business. And if it would be a total tragedy, nobody would do it. So insolvency is normal in economy, and we should also regulate this to make quite clear. Risking is wonderful. It can be a failure in the end. A lot of ideas don't run, but then we have a solution for insolvency and reorganization, and it's on the table as well. The book Company Law, on the other hand, regulates the formation of companies as well as their internal and external relationships. On one hand, the book contains the model of a simplified European company, as already pointed out in the beginning. On the other hand, it refers to the aim of the codification not to be overloaded, and a legal practitioner said not too much rules, better small and precise, and we can do the rest. And that's a good solution that is made in this book. The European Business Code and the simplified European company could therefore be adopted as optional law, and it's good to have it inside. As I said, I can't go through all 13 books, which I would really like, because it's very interesting to talk about it. But it should be clear that we have a draft of experts on the table and the willingness of the Commission to bring it into power. That's why I presented it today. We have a draft, we have the willing, and we have the need. So we should discuss it and bring it forward. As former draft of experts and intentions to bring a 28th regime into power, like sales law I already mentioned, for example, the political need for the business code is tremendous. Compared to the legal draft in the past, other reasons like language barriers, we discussed that a lot in sales law and contract law, are not overlaying the question of this 28th regime. For business, a common playing field or a better solid European law basis is essential. That's why the national legislators are relevant now. We have to push. EU legislation, as you know, is not just happening on EU level. Of course it does, but the national legislators play a crucial role in it. That's why we have to discuss these issues right now. Germany and France, essentially, their parliaments and lawmakers look very close now to the Eastern European partners to put this discussion forward. It's not just because we must find a consensus between all member states, also because the markets in East Europe are livelier, still emerging and business-orientated than the states and governments connected markets, for example, in Germany and France. In Eastern Europe, more and more young people plan or risk to rise and to start a business than in other countries. For example, in Germany, most of the young people want to be public employed by government or state. So we see here more lively, more active markets, and that's why it's so important that voices of East European countries are loud, because you are so innovative and you have a young generation want to do business. So that's why the discussion here is wonderful. Come to my conclusions. So, what does this all mean? As a short conclusion, it can be stated that the EU is on its way, again, to discussing a 28th regime as an EU-wide code, the EU European Business Code. This time, it's a business code for the whole EU as an option. Important are two thoughts made now from my perspective. First, the EU should not overregulate the business code with issues like corporate social responsibility or other political demands that limit economic growth and the will to do business. We all know the discussions what business has to fulfill to accept it. Business has a wonderful role by itself. It creates jobs and so on. I don't have to point out here. So don't overlay it with political issues. The center of the code should be to enable business, to make business possible. Second, the member states should accept and take the responsibility for Europe in total. Subsidiarity is a core principle in the EU treaties, no doubt. But as the EU is one of the strongest economic areas in the world still, based on a strong internal market, it's obvious that we can't have 27 different business codes. even if each country is convinced about the quality of its own law. So, if we take these two aspects into concern, additionally to the excellent work of the scientific experts, we will see in a European business code within the Commission under the working plan Europe's Choice until 2029, hopefully. Thank you very much.
Let's hope. Thank you. Thank you, Professor. It was very interesting because, in my opinion, every jurist considers that codification is the most important step when addressing the legislation. Even if we talk on the national level or in the international level, codification means a lot and it simplifies many problems. And of course, when we discuss about this European Business Code, I think Enrico Letta was right in the report. I really loved his perspective on this issue. And I think it addresses in a very efficient manner the fragmentation of the law. So in my perspective, this would be a very good step in addressing this problem. And of course, it is, in my opinion, the key advantage to strengthen the European single market. So yes, this would be the wise step to do in the future. If there are questions in the room, please don't hesitate to address them. I didn't mention at the beginning, but of course we are open to have discussions regarding the topics that we are addressing today. If not, we will go further. I invite Professor Bianca Maria Predescu to address a very interesting topic also regarding jurisdiction, because when we are discussing about European Union law and national legislation, first of all, we have to talk about jurisdiction. So, Professor, please tell us more regarding exclusive jurisdiction in the area of personal status, the clash between the Code of Civil Procedure and EU regulations. Thank you. Very interesting. Very interesting.
Din păcate am să vorbesc în română pentru că eu m-am așezat în mod firesc pe poziția judecătorului român care aplică legea, care aplică codul de procedură și regulamentele pentru a stabili competența de judecată. Mi-am pus un subtitlu pentru că dacă observăm toată reglementarea atât la nivel constituțional, cât și la nivelul codului de procedură civilă, despre acestea vreau să vorbesc, observăm că, așa cum și profesorul regătatul profesor Ioan Muraru, dar cum și de mai multe ori Curtea Constituțională s-a pronunțat în acest sens, în privința concursului dintre normele conținute în lege și normele conținute într-un regulament, suntem în prezența principiului specialia generalibus derogant și pentru că sunt contrare în înțelesul constituțional al sistemului de drept român, pentru că au reglementare diferită, chiar parțial diferită, norma din lege și norma din regulament, de aceea se aplică ca și o lege specială cea conținută în regulament. Două idei principale. Știm cu toții că în materie de competență de judecată avem norme de atribuire a competenței pe care forul și le reglementează și atribuie competența de judecată prin norme de aplicare imediată, iar în mod particular regulamentele Uniunii Europene în materie de competență de judecată sunt norme de distribuire a competenței către instanțele statelor membre, în raport de criteriile avute în vedere. Același principiu al atribuirii competenței, dar ținând cont și de distribuirea de competență cu care operează regulamentele, îl regăsim atât în articolul 1066 din Codul de Procedură, cât și în articolul 4 din regulamentul 1215 pe 2015, pentru că avem un criteriu principal al domiciliului persoanei, în general reținut de regulament, în sensul legii române, domiciliul persoanei fizice, sediul persoanei juridice, prin intermediul căruia se face o atribuire generală de competență. În acest sens, ceea ce eu mi-am propus să analizăm, regulile privitoare la statutul personal, sunt o normă derogatorie de la cea generală, cu atât mai mult cu cât avem reguli de competență exclusivă în 1079, punctele de la punctele 1 la 5, codul de procedură civilă. Și observăm următoarele. În primul rând, punctul 1 are în vedere actele de stare civilă. Iar cu privire la actele de stare civilă, observăm că nu avem o concurență între legea română și un regulament. Sunt incidente, dispozițiile legii 65 pe 2012, dar ele privesc doar eliberarea certificatului multilingv cu privire la naștere, căsătorie, deces. Ca atare, e cu tot o altă chestiune. Autoritățile române s-au conformat odată cu intrarea în vigoare a legii. Ca atare, în această chestiune, neavând nicio competiție între dispoziția din legea română și cea dintr-un regulament, competența exclusivă își produce efecte depline. Da, m-am jucat puțin și el e foarte atent. 1079, punctul 2. Este o situație relativ asemănătoare în privința adopției și ea este o chestiune rezervată statelor. Observăm că, deși în legea română avem o procedură a adopției internaționale, reglementările din legea română trimit, articolele 61-65, trimit la competența exclusivă a autorității române, iar pe de altă parte, regulamentele în materie, începând cu 2201 pe 2003 și cele până în prezent în vigoare, niciodată nu au reglementat despre condițiile încheierii sau încuvințării actului de adopție cu privire la un minor. Ca atare, suntem din nou în prezența unei competențe exclusive. O situație interesantă, din punctul meu de vedere, este aceea privitoare la tutelă și curatelă. Legea română prevede din nou o competență exclusivă, după aceleași criterii, să fie vorba despre o persoană cu domiciliu în România, fie că este cetățean român sau apatrid. În ceea ce privește regulamentul 1111 din 2019, la articolele 1, aliniat 1 și 2, cât referindu-ne și la preambul, observăm că, în sensul dreptului european, răspunderea părintească include ceea ce legiuitorul român desemnează prin tutelă și curatelă. Pentru că avem, în sensul dreptului european, o chestiune ce privește reprezentarea intereselor minorului, atât cu privire la aspectele patrimoniale, cât și cu privire la aspectele nepatrimoniale, adică tot ceea ce ține de răspunderea părintească. Și sunt mai multe hotărâri judecătorești pe care în analiza mea le-am evocat în acest sens. Numai că în cuprinsul regulamentului, în afară de această dispoziție, în sensul că în domeniul său de reglementare intră și chestiunile referitoare la răspunderea părintească, când începem analiza articol cu articol, de la articolul 4, așa cum începe regulamentul, observăm că nu avem nicio dispoziție expresă în privința răspunderii părintești. În câteva rânduri, Curtea de Justiție inițial a comunităților europene, atâta timp cât a fost în vigoare regulamentul 2201 pe 2003 și în prezent prin regulamentul de reformare a acestuia, s-a pronunțat că instanțele statelor membre trebuie să țină faptul obligatoriu, trebuie să țină cont de faptul că atâta timp cât regulamentul în vigoare 1111 pe 2019 arată în obiectul său de reglementare că se au în vedere și se pronunță cu privire la aceste chestiuni, rezultă că și tutela și curatela în sensul dreptului român sau chiar în sensul, pentru că acolo era în speță, erau două spețe, una cu dreptul polonez și alta cu dreptul francez, au în vedere și chestiunile legate de tutela și curatela minorului. Pe cale de consecință, avem un concurs care intervine între norma de competență exclusivă din codul de procedură, norma din regulament, fiind o lege specială, o normă specială, va deroga și se va aplica cu prioritate de judecătorul român criteriul avut în vedere de regulament, care este chiar mai larg și anume ține cont de reședința obișnuită a minorului, nu de domiciliul minorului, ca atare chiar este o normă de favoare în ceea ce îl privește pe minor. Da. Mergem mai departe. În ceea ce privește o formă reglementată în ultimul rând prin legea română, protecția majorului, este vorba de tutela specială și consilierea judiciară, observăm că prin punctul 4, de asemenea, nu avem un concurs între norma de procedură din legea română și o altă normă cu caracter internațional, fie că ar fi o convenție, fie că ar fi un regulament, atâta timp cât acestea, normele internaționale, se preocupă de situația minorului și niciodată de situația majorului. Trebuie să recunoaștem că aceasta este, de fapt, consecința. Merg mai departe? Oh. Andreea? Mulțumesc.
Pot să folosesc?
Mai tare.
Mai
un touch mai persistent. Ajungem la punctul 5, care, din punctul meu de vedere, este cel mai interesant. Și anume, punctul 5, din perspectiva legiuitorului român, are în vedere mai multe chestiuni. Are în vedere, în primul rând, divorțul, apoi, dacă vom gândi după modul în care avem normele reglementate în regulamentul din 2019, răspunderea părintească, și ultima chestiune este cea privitoare la regimul matrimonial, unde avem alte dispoziții incidente. Cu privire la divorț, observăm două chestiuni, și anume, concursul dintre 1079.5 și articolul 3 din regulament, în afara faptului că are o normă de favoare pentru persoană, pentru că are în vedere ca localizare reședința obișnuită, în plus față de această chestiune, fiind diferite, în sensul legii române, se va aplica cu certitudine reglementarea din articolul 3 din regulament, fiind o chestiune de competență de judecată după reședința obișnuită a soților și nou introdusul criteriul de localizare cetățenia comună a soților prin regulamentul în vigoare. Ca atare, judecătorul român își va verifica competența întâi prin articolul 3 regulament, condiții în care nu se mai aplică codul de procedură civilă, aplicând cu prioritate competența dată de norma europeană. Pentru că avem o chestiune de competență subsidiară, prin articolul 6 regulament, judecătorul român observă că acesta are abilitarea dată de articolul 6 regulament de a aplica cu întâietate norma română din codul de procedură civilă atâta timp cât, observând că nu sunt îndeplinite criteriile din articolele 3 până la 5 din regulament, întrucât niciuna dintre instanțele statelor membre, astfel cum sunt avute în vedere de criteriile regulamentului de desemnare a instanței competentă, în ultim rând, după criteriile avute în vedere de punctul 5, va desemna ca fiind instanță competentă instanța română. În ceea ce privește autoritatea părintească. Mulțumesc.
Da.
Chestiunile sunt similare și anume, în primul rând, avem o aplicare prioritară a regulamentului, același în vigoare, și în temeiul articolului 10 cu privire la o situație particulară pentru răspunderea părintească, și anume instanța care prezintă cele mai strânse legături cu situația minorului, numai în această ipoteză, instanța română va deveni competentă dacă ea este instanța ce prezintă această circumstanțiere prin cetățenia minorului, fosta lui reședință sau a unuia dintre părinți. Criteriul arătat de legiuitorul european la articolul 10 este de asemenea unul subsidiar, pentru că în principal se are în vedere reședința obișnuită a minorului, în raport de care și judecătorul român își va stabili cu precădere competența de judecată. Și cea mai frumoasă problemă din punctul meu de vedere este cea dată de competența de judecată în privința regimului matrimonial sau cum va, după ce criterii își va stabili judecătorul român, competența de judecată cu privire la partajul bunurilor dobândite de soț în timpul căsătoriei și cererile anexe acestei chestiuni. Observăm că în 2016 a fost adoptat regulamentul 1103. Acest regulament instituie o formă de cooperare. În preambulul regulamentului avem, cred că, punctul 16, dacă țin minte bine, din preambul, care arată expres care sunt țările care și-au exprimat intenția de a participa la această formă de cooperare, printre care nu regăsim țări precum România, Ungaria, Polonia, țările Baltice și altele. Sunt 10 țări care nu participă la această formă de cooperare consolidată. Ca atare, în primul rând, trebuie să ne lămurim în ce situație de drept ne aflăm. Noi avem, conform 288 TFUE, regulamentul ca dispoziție adoptată în baza acestui temei legal la nivelul Consiliului și Parlamentului European în procedura colegislativă în prezent, care instituie norme obligatorii. Regulamentul este obligatoriu în toate dispozițiile sale, dar nu și situația 114 din tratat, care se referă la cooperarea consolidată. Iar cooperarea consolidată este, de fapt, o formă progresivă de a realiza un drept comun și mai întâi ea este o formă adoptată de acte obligatorii, act obligatoriu ca atare, norme care se aplică ca atare cu caracter obligatoriu numai pentru țările care sunt parte, în timp și alte țări pot să participe la această formă de cooperare consolidată. Studiind toate portalurile, că este cel al Uniunii Europene sau sunt jurisprudențele, chiar până acum degajate de unele instanțe europene, observăm că avem această chestiune. Eu cel puțin am găsit o soluție cu Polonia și pentru că dacă Polonia nu este parte la cooperarea consolidată, înseamnă că și pentru situația competenței de judecată a instanțelor române, tot astfel se va dezlega chestiunea de drept. Și anume, toate statele care nu sunt parte la cooperarea consolidată aplică cu prioritate dispoziția din legea internă. La noi este 1079.5 Cod procedură civilă, după criteriul domiciliului comun al părților, să fie cel puțin unul cetățean român sau apatrid, instanța română își va stabili competența în materie de divorț, de regim matrimonial. Eu însă mi-am pus o problemă că este obligatoriu să te gândești la toate chestiunile, văzând dispozițiile acestui regulament privind cooperarea consolidată. Și anume, odată, prin articolul 7 din regulament, deci nu suntem parte, dar pentru celelalte 17 state este o normă unică. Prin articolul 7, părțile, foștii soți, pot să-și aleagă forul competent de a judeca cu privire la regimul matrimonial. Prin articolul 20, cred că scrie pe aici pe undeva, da, așa, se dă un caracter universal normelor conținute în regulament. Caracterul universal constând în faptul că dispozițiile regulamentului pentru resortisanți, statele părți, își produc efecte, chiar dacă ele se referă la un for situat în afara Uniunii Europene sau situat în statele membre ale Uniunii, dar care nu sunt parte la regulament. Și în această situație, ce putem observa că va interveni la un moment dat? Este posibil ca părțile, soții, alegându-și forul competent, bine îndeplinind că judecătorul român, săracul de el, trebuie să vadă dacă unul dintre ei este cetățean român sau domiciliază în România, pe criteriul 1070 for de necesitate, mă întorc, judecătorul străin, care a fost sesizat cu soluționarea partajului bunurilor dobândite de soți în timpul căsătoriei. Văzând, să zicem, judecătorul francez sau german, pentru că sunt parte la regulament. Văzând că părțile și-au ales forul competent și acesta este instanța română, în temeiul verificării competenței este o normă obligatorie, verificându-și competența de judecată. Judecătorul francez vede că nu este competent, își va declina competența către forul ales de părți să soluționeze partajul. Dar acesta este instanța română. Instanța română observă că România nu este parte la cooperarea consolidată, dar observând dispozițiile codului de procedură civilă român 1070 for de necesitate, observă că în această situație, în momentul în care instanța inițial sesizată nu își atribuie competența ca atare, nu înțelege să judece. 2. Văzând că părțile și-au ales forul ca atare, ele nu înțeleg să se supună regulilor din regulament, reședința obișnuită comună sau cetățenia comună a părților, judecătorul român vede că pe criteriul avut în vedere atât prin art 4 din regulament și 1066 din codul de procedură civilă român, are suficiente elemente de a-și stabili competența de judecată atâta timp cât o altă instanță nu judecă litigiul și văzând faptul că cel puțin una dintre părți este domiciliată în România sau este cetățean român, în condițiile unit 1079.5, dar repet, for de necesitate, numai ca for de necesitate, se va declara competent să judece. De ce am ales acest ultim exemplu, ultimă situație? Pentru a observa că, în măsura în care acest regulament care instituie o cooperare consolidată, pentru că el dă dispozițiilor sale un caracter universal, chiar dacă pentru statele care nu sunt parte la cooperarea consolidată, ab initio, judecătorul forului din acel stat va ignora regulamentul de cooperare consolidată, doar dacă, și asta e ultima ipoteză de drept, doar dacă a fost sesizat de o altă instanță și dacă își vede îndeplinite criteriile din propria lege, ca for de necesitate, se va declara în ultimă instanță competent să judece. A fost foarte pe scurt explicația mea, pentru că erau foarte multe chestiuni de drept pe care le avusesem în vedere pentru fiecare problemă analizată. O concluzie urmăream și ceea ce spunea colegul nostru Patru înainte. Este în continuare un joc, pentru că suntem în drum, suntem în subsidiaritate, este în continuare o relație între reglementarea europeană, reglementarea statelor membre, în materie de procedură, competență de judecată, recunoașterea efectelor hotărârilor judecătorești străine, fie că este 1215 de 2015 cu norme generale, fie că sunt regulamentele acestea numai în materie de raporturi de familie cu diferite aspecte, unele pentru răspundere părintească și divorț, altele pentru regim matrimonial și așa mai departe, observăm că în continuare avem o parte de chestiuni rezervate statelor, cum au fost actele de stare civilă și așa mai departe, și altele care sunt admise de integrare. Pentru că îl privesc pe om ca și factor de producție, ține de libera circulație a persoanelor, de libertatea de stabilire, de aceea au și fost reglementate, și în aceste chestiuni, normal că, după principiul speciale a generalibus derogant, se va aplica cu prevedere dispoziția din regulament, ori de câte ori ea este incident. Vă mulțumesc!
Thank you, Professor, for this presentation. Actually, you have pleaded how difficult it is to implement the European legislation into the Romanian system, because it's true there are so many problems that arise from this. Thank you very much. Now it's time to give me my floor. Thank you, Andrea. Yes. So the theme, actually, it's an incompatibility between my software and this board. I don't know exactly why we still have some signs, but I hope it will not be disturbing. What I wanted to propose you to discuss today is in the area of CSR. Tackling the EU's corporate sustainability due diligence directive and human rights aspects. For those who do not know me, please have in mind I'm an attorney at law and a senior lecturer in the University of Nicola de Luca Faculty of Law. I teach human rights law and international jurisdictions, and I also hold seminars to general theory of law. So if you see the theoretical part of my presentation, this is like a defect of my profession. What I would like to address today, but of course having in view the timeline of the conference and how Andrea scheduled everything, I will try to make it easier, if I can say like this. I always ask my students, and I always ask the persons with whom I'm talking to address questions in order to see if at the end of the presentation we have tackled everything that I have thought at the beginning. So of course we will ask ourselves, what is this directive if it is new? What are the impacts? How it will be transposed? Regarding the scope, of course, as any jurist, we will discuss about personal and material scope. Regarding the core, we will address the principle and the duties. And as practical measures, of course, we have advices and we have ideas in order to know how to implement it in the companies. But of course, when regarding this directive, we should, at the beginning, address this problem for the big business in Europe, because they cannot ignore anymore the negative human rights impacts wherever they might occur. So what is the directive about? Of course, it is about the corporate due diligence duty in order to address the adverse human rights and the environmental impacts, for example, pollution, for example, child labor. And it doesn't regard only the companies in themselves, so we also have to think to their subsidiaries operations and of course to the business partners, which is new. This is very good in my opinion, because now you have to know your supply chain. So you are not only, you don't have to focus anymore only on yourself, you have to be proactive and see what your business partners are doing. And the second one is the obligation for large companies to adopt and put into effect a transition plan for climate change mitigation in order to adapt to the EU regulations, the business model and strategy of the company that are compatible with the transition to a sustainable economy and with the limiting of global warming to 1.5 degrees Celsius in line with the Paris Agreement, and of course with the objective of achieving climate neutrality. Why was it adopted? Because we think of so many things. At Brussels, you see things different and you want to be proactive and to address problems that are hot potatoes, like we already discussed before. So first of all, protecting human rights and the environment, including the business chains, as I already mentioned, for sustainability transition, and for ensuring level playing field in the single market. And regarding the impacts, you have here, in my opinion, the main impacts of this directive. Of course, human rights protection, protection of the environment, empowerment of local communities, which is very important, and of course, other stakeholders, increased competitiveness of the companies, and driving and striving, if I can say like this, for sustainability transition. But now I think, is it new? What I already mentioned before, maybe you have some thoughts on that, maybe you have discussed it before. Of course, there are some guidelines and there are certain declarations since 1977. So we are discussing, we are addressing this issue regularly, but in my opinion, no steps were taken as before this directive. So we have the ILO Tripartite Declaration of Principles, we have the UN Guiding Principles on Business and Human Rights, we have the OECD Guidelines for Multinational Enterprises, and we have sectoral guidances. But we have to think, is it enough to have these guidances, or should we do more? Because until now, everything is voluntary. Who wants to become like CSR protector? Who wants to implement this in the multinational and the big, large companies? So in my opinion, the European legislator thought that this is not sufficient. So we have to do steps, more steps in this regard, because it is a slow and uneven progress. So we have to do something more. And from now on, in my perspective, after this directive will be transposed into the national systems, the mandatory legal regime will be very clear. Of course, I would also emphasize that at the UN level, there are negotiations now regarding the legally binding instrument on business and human rights. So I think the international context allows us to think to this mandatory legal regime. Regarding the transposition and application periods, Article 37 of the directive. First of all, it was published in the European Official Gazette on 5 July 2024, so it is very new. Entry into force 25 July 2004, the 20 days after the publication. Regarding the transposition, 26 July 2026, so it is like the GDPR. It has 2 years in order to be transposed. And we have special rules regarding the entry into application. We have like X years after entry into force, depending on what we are discussing. We have certain thresholds in order to see when it will be applicable. For example, we have 3 years, so that means 26 July 2027 for EU companies with more than 5,000 employees and more than 1,500 million euros worldwide turnover, or for non-EU companies with more than 1,100 million euros turnover generated in the EU. And we also have like this for 4 years or for 5 years. It depends on which scenario we are. Regarding the personal scope, because we want to know to whom it will be applied. So first of all, of course, to EU-based companies. So this is like the main purpose of the European legislator. So it will be like approximately 6,000 companies in total, and we have 2 thresholds. We have first 1,000, more than 1,000 employees, and second, we have more than 450 million euro net worldwide turnover. It's very important. It will also be applicable to the ultimate parent companies of a corporate group that meets the thresholds, and to franchisors or licensors meeting certain conditions, and you have here the conditions. They have to have a common identity, a common business concept, a uniform business method applied, and they have to generate a certain amount of royalties in the last financial year. And the company had, or it is the ultimate parent company of a group that had a net worldwide turnover of more than 80 million euros in the last financial years. I also underline that this directive, it is not directly applicable to small and medium enterprises, but I underline as a partner, as a business partner of a large company, those companies are also affected. So it is like an indirect effect in the chain of activities, of course. But it also will be applicable, and this is very interesting in my opinion, because it doesn't stop to the EU-based companies. It will always also be applicable to non-EU companies. And those companies have to designate a representative, an authorized representative, to discuss with the authorities of the member state where they have like the biggest amount of money. And they regard like approximately 900 companies in this moment. So the member state in which the company generated most of its net turnover in the EU, and we have the thresholds. But please have in mind that the threshold regarding the employees is not applicable, because it would have been very difficult to know between the legal systems in the world. For example, take China. If it would be China, I don't know how you can count those persons. So the European Commission considered that this threshold will not be applicable. And also have in mind that these amounts of money will be considered met in 2 consecutive financial years. So it is not just for 1 year, but it has to be on 2 consecutive years. Regarding the material scope, as I already mentioned, human rights impacts. I'm very pleased because since I teach human rights, this is like my area where I work so much. In the annexes, you find already the information regarding the rights that would be protected under this directive, and also in the section 2, so that was in the section 1, and in the section 2, we find the list of instruments, international instruments that have to be taken in view. As for examples of human rights, of course, right to life, prohibition of torture, cruel, inhuman treatment, right to liberty and security, prohibition of arbitrary or unlawful interference with the person's privacy or home correspondence, inviolability of the correspondence, of course, prohibition of forced or compulsory work. So these are certain examples. As regards the environmental impacts, we have part 2 of the annex, and there are also given examples: harmful soil change, for example, water or air pollution, harmful emissions, degradation of land, and any other impact on natural resources. So if we go to the annexes, we will see exactly what the European legislator wanted to pursue. But where do the companies have to organize the due diligence? So this is the main question. It is only upstream, it is downstream, both. Actually, actually both. The European legislator thought of both. So it means that on the upstream, it will be related to the production of goods or the provision of services, depending on which scenario we are. I gave you here certain examples: design, extraction, manufacture, development, sourcing. So everything will be covered. And I gave you also an example, a practical example, just to be on the same page. For example, for a car tire producer, for a car manufacturer, a direct upstream business partner will be the tire producer, of course, because I need the tires for my car. And the indirect partner will be the one who makes the rubber for the tires. So just to be on the same page of the upstream. As regards downstream, of course, this is much narrow. It regards the distribution, it regards the transport and storage of the product, and only where the business partner carries out these activities for the company or on behalf of the company, and of course it includes the business partners, the indirect business partners. And I gave you here the example of a producer of clothes, a clothing manufacturer. The downstream business partner will be the retail store that sells those finished clothing products to the consumers, just to be clear. Somebody asked me if an attorney at law, for example myself, I would be an indirect or direct partner. Actually, I consider I would be a business partner in my perspective, because it would be in the chain of activities of a company that is falling into the scope of this directive. This is the abbreviation of the directive, CSDDD. But it will not be applicable, at least not now, to financial services businesses. The Commission said that in 2 years they will develop, they will think if this directive will also be applicable to this area of services. So which are the general principles? We already mentioned. First, prioritizing. We have to prioritize, the companies have to prioritize their actions when they cannot address all impacts, and they have to adopt appropriate measures. I know this is very difficult in practice with my clients. I have so many questions regarding this. What is appropriate? What are the measures that have to be considered appropriate? And here I quote, appropriate measures are measures capable of achieving the objectives of due diligence by effectively addressing adverse impacts in a manner commensurate to the degree of severity and the likelihood of the adverse impact, and reasonably available to the company, taking into account the circumstances of the specific case, including the nature and extent of the adverse impact and relevant risk factors. And I end my quote. So in this definition, I think we can include so many things. But of course, these appropriate measures have to be effective and reasonably available and proportionate. Regarding the duties, integrating due diligence, identifying, assessing, and prioritizing, we have to do a broad mapping, like in GDPR, and addressing negative impact in order to prevent or to mitigate. What is interesting, that the European Commission in this directive underlined that when all other actions have failed, the large companies have the possibility to suspend or to terminate the business relationship. But this is like the last resort solution, if I can say like this. What I wanted to also to show you, I will skip this slide because we don't have so much time. What practical measures do companies need to adopt? And here you have certain recommendations. First, developing and implementing prevention and corrective action plans. This is the first thing, but of course only for complex issues. Second, seeking to obtain contractual assurances. So you have to make sure that into your contracts you include assurances from the direct business partners, including cascading requirements through the chain of activities. This is very important. Third one, making the necessary financial or non-financial investments, including in the chain of activities. D, providing support to the partners. Providing financial support to their partners where compliance with the code of conduct or the prevention action plan would jeopardize the viability of those companies. Adapting their business plan strategies and operations, and collaborating with other entities to resolve the issues. Of course, that in 2 years, the Commission has oblige itself, if I can say like this, to issue certain guidelines in order to help large companies to comply with the directive, and of course to give some model contractual clauses in order to insert in the contracts. So first of all, they have to send questionnaires to the significant suppliers and service providers, and afterward request such supplier or service provider to confirm his compliance with the code of conduct. And I strongly recommend that those companies, large companies, and not only large companies, the ones that want to implement the principles of this directive, to be proactive and to organize themselves in order to draft this kind of documents. This I already mentioned. So let's talk about enforcement. Maybe it's more important than the conclusions because we don't have time. So we will have, first of all, we will have administrative supervision. There will be authorities independent that will supervise the activities in the member states, and they will act based on complaints or on their own motions. We will also have the European Network of Supervisory Authorities, so that will assure the EU level coordination and cooperation. And of course, the directive and the states, the member states, will have to find out proportionate and dissuasive penalties, including fines. And you see here the minimum cap, more than 5% of the company's net worldwide turnover. So I think like GDPR, this is very meaningfully, if I can say. As regards civil liability, where harm to a person's legal interest protected under the national law is caused by intentional or negligent failure to comply with the directive's provisions under Articles 10 and 11, in case the company will be liable, of course it will have to provide full compensation, but those persons cannot obtain overcompensation just to have. So company not liable if the damage is caused only by the business partners in the chain of activities, but still I think those companies will have to prove that they tried to help those companies to adapt. And I think we can end here. You also have the concluding remarks, so this is not a new idea, what I want you to understand, but it is improving each time, each year, the European legislator tries to improve. It establishes a general horizon framework, because in my opinion it is lex generalis. And first of all, it makes cross-reference to existing legislation, and this is a very good point in my opinion, because it also addresses the reporting under the Corporate Sustainability Reporting Directive. So it avoids duplication. So in my opinion, this is very good. So in reality, what is this directive about? It's about complying, being proactive, trying to manage to implement the principles in your business. And of course, I think it's time to know your business partners and the chain of activities. So you cannot stay only in your home, if I can say like this. So thank you for your attention. If you have questions, I will be very happy to answer them, or at least during the coffee break, because now I don't think we will have time. Thank you, Andrea, and I will take my moderator planning. I invite Senior Lecturer Livia Kalin to tell us about current issues in the area of freedom, security, and justice, refugee protection, asylum, and extradition. So you remain in my focus area of human rights. Thank you for coming us today. I know you are coming from Craiova. Thank you very much for being today with us.
I'm not going to be so much fun as my colleague because my presentation is a bit more... Lasă prezentare. Nu. Am arătat multe chestii. E un PowerPoint. So my presentation is not going to be so much fun as...
So was it fun? Okay, thank you.
No, I mean especially the visual part, because it's not so very colorful. It's mostly blue, and although it's similar because it's also about European law. Mine is a bit more towards public law and criminal law, because this is my field of expertise. So what I'm going to try to make it a bit more fun and interesting for you. because it's a social, because it's an economic faculty, and so I try to adapt to the name of the conference and to your specific. Does it work?
Would you need
The
to
PowerPoint?
change places to be
No,
here
I'm
near
gonna
the
be
screen?
okay. Anyway, it's going to be just a couple of them as a
I have some problems, I don't know why.
că nu mai am astic, dar nu merge ca și deschis sau trebuie să se cheme ASE prezentare.
I found it, and I don't know why it's not opening.
Cred că trebuie să cauți altă... Da, nu am ce merge acum. Da, sau... încercați stick sau poate e o problemă cu asta? Nu, cred că programul de deschis.
Da.
Cred că era programul de deschis. So my presentation, it's about current issues in the area of freedom, security and justice, and especially analysis of refugee protection, asylum and extradition. I thought that this topic would be very interesting and actual because we face in Europe like never before these particular situationships, especially because of the war going on and because of the people free of movement, which is encouraged more than ever, and also because protection of human rights also encourages asylum getters in Europe. So my presentation, mă încercăm la stick? Mai am
Another stick?
Da, trebuie să mai încercăm programul de din
Was it nice?
Yes.
I fly through the presentation
Yes,
because
but
I
it was
thought it would
very
have
clear.
more
It was very clear.
time.
Political discussion on it is interesting.
Yes.
So again, we have
Yeah.
problems, sorry.
that techniques like the last conference.
But criminal law always supersedes the presentation,
I think
so
that's
please.
So that's why now I
I think it's
understand.
Russia and China involved.
Yes.
Yeah, I try to not to make names, but of course, during my research, of course, I met Ukraine situations and Kosovo situations, references too. But I try to make it a more theoretical approach. Me as well as my colleague, I'm also a lawyer for over 20 years, and I also teach law, as I said, criminal law and international law at University of Craiova. So a bit of words about asylum and extradition as theoretical approaches.
It's not accepted, this type of...
No, okay, so. Let's go.
Sorry.
So, a few quick reminders for all of you. Probably you're not very familiar if you're not in the study of the particular theoretical problems. The decision to grant or reject asylum application can have important and long-lasting consequences for diplomatic and geostrategic relations between states, as well for the efficiency and legitimacy of international agreements and treaties. As a short history that I had on the presentation prepared for you, but probably you know a little bit about it. It's about the Declaration of Human Rights, which provides in Article 14 that in case of persecution, everyone has a right to seek asylum and to benefit from asylum in other countries, and this right cannot be invoked in the case of criminal prosecutions based on the commissions of a common law crime or on actions contrary on the purpose of our principles of the United Nations. Also, we have the Declaration of Human Rights, a document which also has both moral and political and legal value. Then again, the United Nations Conventions of Geneva regarding the status of refugees, and the protocol relating of the status of refugee concluded in New York in 1967. So all of these international treaties and agreements all have into main interest the protection of the life and the rights of the citizens, which are trying to get protection in another states than their own nationality, because usually, of course, of dramatic changes in their life. These international treaties are, of course, applied in the European space, but in the European space we have more particular and more delicate situations because, as we all know, we have a bigger enforcement of the treaties, trying to bind states together and trying to create the space of liberty, security, and justice. And this comes with both parts of it. On the one hand, the privilege of free traveling and granting people this free movement, and on the other hand, in trying to provide security for all citizens inside of the European borders, of course, states are compelled to do more dramatic and more and to take more security measures in order to enforce the power of the state and of the conventional binding them into granting security.
We have it.
Yes.
Thank you, Andrea.
So Andrea is worked her magic.
Should I
No,
skip the slides?
First or second, it's about what I said before.
This, but I can help you.
I thought you have.
I offer my
I thought you
services.
have a remote. No.
Yes.
Okay.
No.
It's a PDF.
So, as I said before, it's the Geneva Convention and Asylum Convention that I mentioned before. In the European space, as I said, which has a more particular part, we have this common European. I'm going to try it. Common European Asylum System, CESA, which includes a list of directives and regulations that try to implement, as I said, and applies to the third country nationals and stateless persons who submit for an application for international protection on the territory of a member state, including at the border, in the territorial waters, and in the transit state. As I said, we recently... too much probably? Oh, no, it's okay. As I said, although we have all these international conventions that govern the asylum protection for citizens, in European countries, this protection is, although it's one of the most wanted, most of the people around the world try to get to Europe mostly because of this, because of the human protection that we offer. But the asylum is also difficult to obtain. So, as I said about this European asylum system, a bit even more different than the other international agreements. Now, UN Refugee Geneva Convention, the protocol relating to status of refugee, United Nations High Commission for Refugees, and the CESA, as I said, has this, given that fundamental rights are guaranteed by the European Convention for the Protection of the Human Rights and Fundamental Freedoms, as the result from the constitutional traditions common to the member states, constitute general principles of union law, and also inside of this European asylum system, we have this, inside of this area of freedom, security, and justice provided, and also there is according to Article 18 of the Charter of the Fundamental Rights of the European Union, people have the right to asylum, which is guaranteed in compliance with the rules laid down by the Geneva Convention. So, Europe, more than any other international state, tries to do so for the people who seek asylum in foreign states. A bit of a definition of asylum in Romanian legislation is not precisely explicitly said, define the asylum, but we can understand it from the doctrine and from all the other analyses. It's about the hosting and the protection of the Romanian state granted for foreigners and stateless persons because in their country of origin they are pursued or persecuted for activities carried out in favor of humanity, progress, and peace. We have, of course, in the national law such provisions in different types of law, like in the Constitution, of course, in Article 18, in the fundamental law, which provides that the right to asylum is granted to and withdrawn under the conditions of the law. We have several Romanian national laws said there, which derives from the international conventions that Romania became part of granted validation in the Romanian law, ratifications. And also we have the law on asylum, precisely said like that, with, of course, subsequent amendments and additions, which establish the legal regime for foreigners who request protections. Of course, the principles governing the asylum procedures, as provided by the law, is the right to the procedure, non-discrimination, situation of vulnerable persons, family unity, and all the others, and so on and so forth. I'm making this just as a general presentation about the theoretical part and the rights that comes with the asylum, because I'm going to check out more, I'm going to talk more in the end, and I don't think I have so many slides, about these particular issues that can arise from the extradition demand requirements and asylum protection. So this is the parallel I'm trying to do with my paper, and it's of course going to be more elaborated when it's going to be finished. The definition, as I said, of refugee highlights the condition the people are in, which are justified fears of being persecuted. And this, of course, combines a subjective element, state of fear, and an objective one, the requirement of a justified character of the fear. We also have in the Geneva Convention in Article 33 an important principle that is also part of the asylum big picture in the granting asylum. We have the principle of non-refoulement. No contracting state shall expel or return in any way a refugee across the borders of the territories where his life or freedom would be threatened for reasons of race, religion, nationality, belonging to a certain social group, and political opinion. This is also mentioned in the Romanian legislation, and you have here the definition. Why is this so important? And this was always a topic that interests me a lot. I even teach my students a lot about it, and and insist on this, because as we can see, somehow, for example, as you all know, from the constitutional provision, the extradition of the nationals, the Romanian citizens, is forbidden, and it's pretty much similar in all the other European countries. Nevertheless, for the extradition of the nationals, we have exceptions provided in the Constitution, and then there comes the special law of international cooperation, which provides situations described precisely in which Romanian citizens, or nationals, European nationals, can be extradited, especially between the member states. But the asylum seekers and the asylum beneficiaries in a state do not face the possibility of being extradited. This is exactly the base, the ground of it, because seeking asylum is sometimes exactly because of that, because of their being part of a race, religion, nationality, a certain social group or political opinions, or a certain particular situation in their country. So seeking asylum in another state and obtaining asylum in that state, sometimes they can elude they do not face the consequence of being extradited in the country, although in that country they may be they must appear in front of a criminal in any criminal case. So now that we made this a bit of a theoretical presentation about what it requires, I'm going to insist a bit more about the security considerations, because and I'm going to make now the parallel that I told you about between the private law and the European business, the European economic and private law to my field, because there are a parallel that was made by a lot of authors in these matters that said that the creation of the single European market has been accompanied by an intense discussion of whether market-creating measures are privileged under market-correcting measures by the institutional systems of the EU, and the results of such an imbalance would be alarming to everybody concerned with the welfare state and the European social model. And this parallel and this analysis can also apply to the public law and to the criminal law, because the creation of an area of freedom, security, and justice launched by the Treaty of Amsterdam poses a similar question, you know. So, will the balance between security consideration and individual rights shift towards the former at the expense of the latter? So, as I said before when I started my presentation, it's about that. We all need and desire, and we are willing to accept, you know, all conditions in order to have this European space as as I said, a space of freedom and security and justice. But would we also be willing to give up and to accept all conditions which so that the security is guaranteed for all the citizens? And the discussion is exactly that. Security or fundamental rights. Most of the authors, this is what they consider, that in trying to implement this area of freedom, security, and justice, sometimes it's exactly the fundamental rights that are being a bit, I don't know, let's say neglected, diminished. We cannot say, we cannot completely elude them, but critics said that it's a bit of a shift down for them, because security measures special prerogatives for the governments, including in the area of immigration, as I said before, and asylum is one of the component of one of them, one of these problems, are common instruments, and have European agencies that take care of this. This gives autonomy for the national government through intergovernmental cooperation, as I said, and I'm going to take up some more about these instruments of international cooperation between states, and especially European instruments of cooperation between states. Also, security seems to undermine the other two goals. So, freedom and justice seems to be top seems to be 2 and 3 on this podium, and security somehow becomes the main interest. And also, critics consider that these repressive measures taken by state, sometimes, and of course justified by the need to protect citizens, can threaten civil liberties. There is a risk that fundamental rights will be neglected in favor, as I said, of security measures, and this concern also expressed, it is expressed within the European institutions, which recognize that excessive emphasis on security can undermine the respect for fundamental rights. Okay, I said it's very boring. It doesn't have pictures. It's all blue. So I chose blue because of the European. All my presentations about European Union that I do, I always made it blue because. And I'm also from Craiova, as I said, and our local team has a blue color, so yeah, forever blue. So. The main principle that helps inside of the European space to assure security and freedom and justice is precisely this one, the principle of mutual recognition. A short presentation about judicial cooperation in the international field. It requires a part of administrative cooperation between states, between the government, between the Minister of Justice, the verification of a certain international convention between states and all that. Inside of the European Union, this cooperation takes place more easily. Sometimes even this exchange of documents and requirements never go through all the administrative process, because we have this as based on our cooperation, which is the principle of mutual recognition, and is based on the assumption that the member states meet the standards of human rights protection set out in the European Convention of the Human Rights. As you all know, all member states of the European Union are also members of the European Convention of Human Rights. So then we start up with a certain presumption, that these requirements are met, and we do not have to check them again and again and verify and make sure that the other member state fulfill these demands. So the operational cooperation occurs through networks of justice and home affairs officials, informal common law operations such as border control or joint investigation or creation of special agencies. I have here a list of them: European Police Services, Europol, European Network, Judicial Cooperation, Eurojust, European Justice for Management, Task Force of Police. As you can see, they are mostly police cooperation agencies. They do not have, they just help into, as the name said, into this cooperation, into finding, identifying the person in question of a criminal procedure in a member state. But in the end, the decision, most of the time, especially in the Romanian case, it's a judicial decision. So the judicial powers in the member states are the ones that decide whether the person can be can make part of can be extradited. So it's not quite a conclusion, but as I said, at the point I became lazy and didn't finish all my presentation on like that. I'm going to make a couple of new mentions on this procedure, if I can find it. So the creation, as I said, of the European single market has raised important questions. Where is it? Yes. Important question about the priority of market-making measures over market-correcting measures, as I said. And since the beginning of the cooperation in the field of justice and home affairs, this sector has rapidly evolved. And this transition was an important factor in legitimizing the continuing European integration. Critics, as I said, try to trend that security seems to undermine the other two goals, as I said, freedom and justice. And repressive measures can, in this context, often justified in order to protect the citizens, sometimes can threaten civil liberties. And so I'm not going to take more of your copy corrected. I know that's coming right up, and it's, of course, it's necessary, even more necessary than that is the copy. So the autonomy and generating effects of internalization are especially strong for democratic states, yeah, and we can say that in the European Union we mostly talk about, we all are, and it may particularly be important in the fields that are close to the liberal core, convincing that the existence of different systems of law should become more compatible. Of course, we cannot talk about a uniformization throughout Europe of the criminal law, but we can make them a bit more similar and homogeneous in order to implement this security state. Of course, there is no doubt that the question that immigration, organized crime, and terrorism have become securitized, and for this, as I said, the government takes all the measures. The governments take all the measures and create all the kind of national agencies required and necessary in order to sustain the cooperation between member states. Because in the European Union, this cooperation, as I said, should be more intense. So, as I said, because coffee is better than everything, I'm going to conclude my presentation with this, leaving you somehow, even with this question for you to ask yourself, and of course stop the conversation later and take the coffee break. On one hand, at international level, the protection of refugees and asylum seekers aims to assure compliance with the principle of non-refoulement, as we all said. This is a humanitarian principle, trying to assure people of their rights to life and freedom and the respect of their human law, of their human rights, but also as well as to avoid limiting the rights and guarantees of asylum seekers during the asylum procedure. On the other hand, national regulations must take into account equally for the need of efficient functioning of international judicial cooperation mechanism in criminal matters, which he aims to eliminate all the worst forms of crimes. And because of this easily movement of the people around the world, as we all know, organized crime and terrorism are sometimes the worst threats that humanity can have. So asylum systems of the EU member states are faced with unprecedented flows of people, as we all know, requesting international protection. And that's why the continuous improvement and efficiency of the legal framework regarding asylum is a priority, ensuring the optimal balance between the conditions and goals of the two institutions, but of course with full respect for fundamental rights. As I said before, because of this, security or fundamental rights, remember, the question mark. And as I said at the beginning of my presentation, that I'm a lawyer, for me also, any presentation must end with that. Full respect for fundamental rights. So yes, we try to make a more efficient international cooperation, especially between member states. We try to assure security, but do not forget and never breach the fundamental human rights just for the sake of security. Thank you.
Thank you, Livia, for your presentation. Thank you for the presentation. I hope we convinced you that in the first part of this panel that we are discussing about civil law, criminal law, European law. We are jurists and we like to speak and we have so many things to say. Sorry for the little delay, but we invite you to the coffee break and we kindly ask you to come back in 15 minutes in order not to disturb the entire schedule of the conference. Thank you very much.
Thank you. Oh, yes, sure. Thank you.
At the University of Police, we look sometimes at effectiveness,
Oh my God, that would be great.
topics regarding the European law and the European perspectives, if I can say like this. I kindly give the floor to prosecutor candidate Horia Tugan regarding the topic European law and the obligations of internet service providers and social media platforms in reporting child sexual abuse. Please, you have the floor.
Thank you very much, and beforehand, thank you for having me here. It is the first time I participate in a conference that's organized by the university, by the Economics Academy. I'm honored to be here, and I'm sorry for the before mentioned speakers for not being able to participate from the beginning. I had classes at the Economic and International Relationship faculty, which, as you might know, has moved rather far away. Relating to the topic of today's conference, that is business policies, EU law and business policies, I have to affirm that it was before, far and foremost, a challenge due to the, let's say, rather different nature of the topic in contrast to my field of study and at the same time of work, which is that of crimes perpetrated, sexual crimes perpetrated against minors. So at the same time, having in mind the fact that we are witnessing a change both in legal spectrum and social spectrum towards the way society reflects upon the concept and the nature of consent, minors, and their freedom towards their sexual liberty and health while developing. And for that matter, we are witnessing a period in which law is the motor behind the social change and not vice versa. So for that matter, in trying to combine the two of the elements that had to be put together in the written paper, I will talk about the changing perspective in the liabilities, the obligations and provisions under the broader spectrum of European law, or law of supranational European law, in regards to legal persons and their obligations towards identifying, complying to standards relating to what literature calls CSA, which is children sexual abuse material, that has also a legal definition. But before that, as a brief introduction, I have to make this reference that is in a criminological perspective. It has been stated and rather argued in literature that can there, or the question was posed, can it be that the internet and the proliferation of social media platforms, of digital fields in the broader spectrum had created a new type of criminality, or had it just given the tools of already existing perpetrators to be or become in contact with their victims. And for this matter, it is relevant to point out that in institutional studies and also academia studies, it resulted that in a large number of cases, people, perpetrators of child sex offenses, sexual offenses, had no prior record, are people that are integrated socially, and in most of cases, or in a significant amount of cases, they are shy people, and they don't fill a room. And maybe this is what the internet has done in this spectrum. That is, or not the internet as a concept, as a network, but the means of socializing on the internet has given a tool in maintaining the anonymity, and thus the possibility of entering into contact with possible victims, the anonymity being the same reason or coming from the same motive as the shyness, the difficulty in preventing such offenses. So, in this respect, moreover, now that we have seen, and it was also observed at the European Union level, taking into consideration the 2024, I think it's ongoing as legislative procedure, that we have entities, legal persons, that gather and have huge amounts of data, and they have platforms that are algorithmically driven to emphasize certain interests of people, and thus making profit out of it. But at the same time, we had our legal framework, as stated by the Commission, European Commission, was somehow permissive in this respect. So, for this matter, I'd like to point out the systematical or historically systematic way in which we have moved from a simple GDPR privacy generic spectrum of this matter to a more locally and focused approach on this matter, which is after Directive 93 in 2011, where it was recommended for the member states to take take up all means necessary in preventing and regulating the data usage in respect to child sex abuse material. On the other hand, this approach was somehow declarative rather than efficient. So a change had to be made, and that came under the not pressure but influence of the Lanzarote Convention and what I thought to be and is the central piece of this evolution, the Shrem II decision, in giving for the first time an analysis towards the social necessity of compliance, of big data generating and managing companies. And under the reports and the recommendations of, and under the influence of the recommendations and the reports written on behalf of the Lanzarote Convention, when they, it can be seen as an obligation in terms of wordings that we are shifting from recommendations to obligations, from mays to musts. We are seeing the same thing under the European Union law, not just the international human rights law, European human rights law. So in this perspective, I would like to point out as a matter of fact that after the Schrem Convention, the Schrem II case and decision, we are witnessing a victim-centered policing mechanism limited by the standards of proportionality and necessity in regards to the prevention of child sexual abuse material proliferated on social media, and moreover that is being profited on with almost impunity. And for a brief closing statement, as the result of this shift in perspective, both social and legal framework, it should be pointed out that the closing circle of this aspect is not the regulation 2065, but the procedure of amending the directive from 2011, and which was the cornerstone, the first major cornerstone in EU law in this perspective. And this is change in the make. Thank you very much.
Thank you very much. It is very important to know that under the European law, we don't have only rights, we also have obligations. And nowadays, when we have so many problems regards hate speech, I think it's very important. It's a very important topic to address. Thank you very much, Mr. Tugan. And I give now the floor to my colleague, attorney at law and PhD candidate, Costin Chiriță, in order to address the topic Draghi Report, Legal Perspectives. It is a very short and clear title, but I'm sure that you have so many things to tell us about.
Well, actually, we don't have the whole day to talk about the whole report. As far as the Draghi report is concerned, from a legal perspective, firstly, it's important for us to understand what it is and what are the main focus area for this report. Firstly, the Draghi report is a report written, drafted, as the name says, by the ex-Prime Minister of Italy, Mr. Draghi, as a request from the European Commission in order for us at the European level to understand where we are and what our future plans are regarding the well-being, basically, of all European states. Firstly, Europe, more than any other continent, has faced multiple challenges in the past 5 years. We started with the pandemic, then we went on with the Ukrainian war, which actually, instead of making us stronger, made us a lot weaker. Our main strengths, cheap energy, competitiveness, actually transformed into weaknesses. Why am I saying that? Just as an example, in 1960, Italy had a bigger GDP than India and China together. So the economy around us changed a lot, and we didn't manage to keep up with it. The Draghi report basically is addressing this issue, establishing what are the key points for the European Union starting from now on, and how this milestone should be actually completed. The Draghi report is focusing on innovation, on competitiveness, on defense, and moreover than that, focuses on budgets. The budget that this report is talking about is about 800 billion euros. And this is a rough estimate because, in my opinion, and as far as I searched and researched, the actual cost could be at least double. Well, how are we going to do that? And most importantly, how is the legal framework of the European Union actually prepared to face such a problem? Unfortunately, at this moment, we don't necessarily have the legal framework in order for us to be able to sustain such an ambitious plan. As far as the recommendations are concerned for the adaptation of the legal framework is concerned, the Draghi report is talking about changing the decision-making process. As we all know, under the provision of the treaty, at this moment, the decision process ping-pongs among the Commission, the Council, and the European Parliament. This whole procedure is, in the best case scenario, takes at least 18 months, which is unfortunately too rigorous. As we all know, the legal system, the legal norms should actually reflect the society. How would that be possible if the society is reflected 18 months after? So this is the first and most important aspect. The Draghi report is referring to also the attribution of the European Union. As we all know, at this moment, the European Union has limited, as a whole, exclusive prerogatives as far as decisions are concerned. From this point of view, we need to enlarge, to increase the European Union possibility of decision. As we heard before, the European Union is confronting and working on a new European contract. The European Union is discussing and promoting a European financial system, integrated system. Well, unfortunately, these steps and this discussion, and as our colleague already told us, the discussion started quite a long time ago, and the decision has not been yet made. Unfortunately, this is still affecting everyone. Other legal provisions that might be or should be changed are considering the competitiveness, the antitrust and the competition rulings, Articles 101 and 102 from the treaty. Unfortunately, we as the European Union focused on making a level playing field within the European Union, but we haven't taken into consideration the whole geopolitical structure. From this point of view, instead of trying to, and the Draghi report states that and proposes that, instead of actually talking and considering fights, if I may so, or rules against fighting within the European Union, we should consider the whole world. While the European Union, for example, in the past 5 years has passed around 13,000 legislative projects, the US Senate and the US legal framework has passed only 3,000. So we not only are just over-regulating, but we also tend to over-regulate against ourselves, while the other continents like the US, all the Americas actually, because Brazil is also quickly expanding and growing, India, China don't really care about this stuff. All these elements that we are over-regulating in other countries are a given. Moreover than that, as far as the subsidies are concerned, another important aspect from the Draghi report, we tend to limit ourselves. And we see in the green energies market, because as I said at the beginning, because of the war in Ukraine, energy in Europe has, well, begin to be scarce, and the prices rises continuously and continuously. And we want to change the gas-driven economy to a green energy economy, but all the green energy is produced with Chinese equipment, which is from this level kind of, I don't know, at least not smart, let's say that. So all these elements that are concerning the development of the European Union as a whole should actually be of concern of every state. And Draghi report proposes, considering this legal framework that should be modified and adapted, to incorporate a master plan for Europe, so that not every country should just focus on what their needs are and what the development of each country should concern, as we've seen in the PNRR. Each country, national resilience plan, right? Each country establish what their main goals are. But the pandemic actually affected the whole economy, right? So we didn't think at the macro level in a form of actually developing the European Union. So from my point of view, I don't know, I think I have 2 minutes. Okay. As a conclusion, because once again, even if I talk the whole day, even it's impossible. It's impossible to comprehend what the Draghi report is, and I'm not talking at the level of understanding it, because we can understand it. But we are facing a moment where decisions should be made in order for us to actually be competitive in the future, because it's not sustainable anymore, right? And I read something yesterday. It said that the optimistic and the pessimistic all have both have a place in this world, because the optimistic invented the airplane and the pessimistic the parachute. So whatever the direction might be, we should take in consideration all options. But my proposal, and I mean my analysis, is that whatever we are doing, we should be doing it faster.
Fast.
That's it for me.
Thank you very much. Thank you, Costin. It was very interesting, and it is true. We can discuss later regarding the Draghi report during the lunch break, why not, and regarding all the topics, because we didn't have time to ask questions. I kindly invite Associate Professor Horatiu Răzvan Radu, who is the next speaker in the panel, to come in the panel. You will address the topic of the CIG reform implications for practitioners. And I have to confess something. I was very happy when I saw Professor Radu in the panel, because actually he's one of the professors who I follow very, very close, because I'm very interested in the human rights, as I mentioned before, but he's not paying attention. But the idea is, I know very good the high quality of the topics he addresses.
Okay, thank you for this kind of presentation. Unfortunately, a lot of the time has exceeded. My mission is quite difficult because I have to be quite brief. My topic related to the reform of the Court of Justice of the Union, of the European Union, and the implication for practitioners, I hope to be very interesting, at least from this practical point of view, because European Court of Justice carried out a huge reform during the last years. I may say that the reform started more than 10 years ago with doubling the number of judges to the General Court. At this moment, the main reform was related to the preliminary reference, but not only to this. I'll try to point out some ideas and to try to explain, first of all, what's the purpose of this reform, and secondly, which were the steps and which are the steps for the time being, because the reform entered into force on the 1st of September 2024 and is effective starting from 1st of October. First of all, first part of the reform regarded the implementation of the transfer from the Court of Justice to the General Court of part of the jurisdiction to give preliminary rulings is part of the extension of the reform of the judicial framework of the European Union, and this affected the preliminary references since 1st of October. I'm not so handling. Okay. The aim of the reform is to reduce the workload of the Court of Justice, because you know very well the Court of Justice has to deal with a lot of preliminary rulings. Although the Treaty of Nice had provided for the possibility of the General Court being involved in dealing with certain requests for a preliminary ruling, the statute has not amended until now and has not adapted for this purpose. Therefore, the statute was amended by the regulation 29 since 24. Okay, this is the regulation. As I told you, the regulation entered into force on 1st of September, but the reform is fully effective, started with 1st of October. Mainly, the reform consists in three parts. First of all, as I told you, the transfer to the General Court of part of the jurisdiction to give preliminary rulings. Secondly, changes applicable to all preliminary ruling cases. And thirdly, extension of the mechanism for the determination of whether an appeal is allowed to proceed. Regarding the transfer to the General Court of part of the jurisdiction to give preliminary rulings, this is the first part of the reform, and what I should mention here is the fact that we have 6 specific areas where the competence was transferred to the General Court. The common system of value-added tax, excise duties, the customs code, the tariff classification of goods under the combined nomenclature, compensation and assistance to passengers in the event of denied boarding or of delay or cancellation of transport services, and the system for greenhouse gas emissions allowance trading. These are the main areas which, starting from 1st of October, will be dealt by the General Court. Of course, as a lawyer, as a practitioner, you will ask what will happen with the preliminary references from member states. From this point of view, the situation is quite clear, because for reasons of legal certainty, the transfer concerns these areas, but the cases should be submitted to the Court of Justice, and then the Court of Justice will analyze its competence and will transfer to the General Court if needed. Of course, this implementation, because it was not only the statute which was amended, it was amended as well the procedural rules, the rules of proceedings of the General Court and the rules of proceeding of the Court of Justice of the European Union. Regarding the amendments to the statute, the provisions that are necessary to enable the transfer from the Court of Justice to the General Court of part of the jurisdiction to give preliminary rulings. This is the main amendment, as I already underlined. Regarding the amendments to the rules of procedure of the Court of Justice, the reform stressed detailed rules for the initial processing of requests for a preliminary ruling submitted to the Court of Justice in order to determine which court has jurisdiction to deal with them. They introduced provisions that are necessary to ensure that requests for a preliminary ruling that the General Court refers to the Court of Justice on the ground that they require a decision of principle likely to affect the unity of consistency of EU law are dealt with swiftly, and detailed rules for the online publication within a reasonable time after the closing of the case of the written observations submitted by interested persons in preliminary ruling cases that will be the subject of the decision from 1st of September, unless such person objects. I think this is also very important for practitioners, and this will provide practitioners with more so-called transparent stuff for working for other cases. New provisions which aim to take account of the experience gained during the health crisis expressly provide for the possibility for the parties or their representatives of making oral submissions by video conference. That means online hearings, because the Court of Justice tried this system during the pandemic. In addition, rules on the protection of personal data and on the methods of lodging and service of procedural documents have been clarified, and the broadcasting of hearings before the Court of Justice, which contributes to the transparency and the accessibility of justice. The arrangements already put in place for hearings before the Grand Chamber and for the delivery of judgments and opinions are now set out in a new provision. Regarding the structure and the organization of the General Court, because this reform affected mainly the General Court, in my opinion, the main change was the creation of an intermediate chamber sitting with 9 judges, between chambers sitting with 5 judges and the Grand Chamber sitting with 15 judges. This intermediate chamber is presided over by the Vice President of the General Court, and the request for preliminary ruling will be assigned to chambers with particular responsibility for hearing and determining those cases, sitting with 5 judges, without prejudice to the possibility of referring them to another court formation, depending on the difficulty and the importance of the case. Regarding the general advocate system, because according to the rules of procedures, we had in the former rules of procedure the general advocate and the general court with a specific role, but not a separate general advocate as we have to the Court of Justice. Therefore, the rules of procedures, the rules of procedures of the General Court were revised accordingly, and the judges called upon to perform the duties of an advocate general in preliminary ruling cases, and those called to replace them if they are prevented from acting are to be elected by the General Court and assist the competent court formation in all preliminary ruling cases, mirroring the participation of advocates general in proceedings before the Court of Justice. That's the main important structural modification in my opinion. The General Court tried to copy, if we may say, the Court of Justice organization system regarding the advocates general. The procedures under which requests for a preliminary ruling transmitted by the Court of Justice will be dealt with the General Court, and in order to provide national courts and tribunals and as well interested persons the same safeguards as are applied by the Court of Justice. The General Court has reproduced the provisions of the rules of procedures of the Court of Justice that are applicable to requests for a preliminary ruling, subject to any adjustments necessary to maintaining the overall consistency of the procedural provisions applicable to the General Court. Other amendments, important amendments, which are also part of this reform, and I try to point out some of them. Removal of registry charges for extracts from the register of the registry, copies of procedural documents, and copies of orders and judgments. Modernization of the rules regarding the methods of lodging and service of procedural documents. Possibility of proceeding by way of simple decision in order to take procedural measures, which so far require the adoption of an order. Limitation of the period for the lodging of a modification of the application where a measure of the annulment of which is thought is replaced or amended by another measures with the same subject matter. Possibility of adopting directly a measure of inquiry requesting information or the production of material without prior adoption of a measure of organization of procedure. Clarification and streamlining of the rules concerning the assignment to a court formation of ancillary claims. For example, rectification, failure to adjudicate, and so on. And lastly, the broadcasting of hearings before the General Court, which will be possible only after the entry into force of an implementing decision. And the last part of the reform, the so-called reform on appeals. I mean the extension of the mechanism for the determination of whether an appeal is allowed to proceed. This part of the reform is intended to maintain the efficiency of appeal proceedings against decisions of the General Court in view of the high number of appeals lodged with the Court of Justice. In order to allow the Court of Justice to focus on the appeals that raise important legal questions, the mechanism for the determination of whether an appeal is allowed to proceed is extended to other decisions of the General Court. The mechanism for the determination by the Court of Justice of whether an appeal is allowed to proceed concerns appeals in cases which have already been considered twice, initially by an independent board of appeal, and secondly by a body of the agency of the union. And this amended to the statute is related to these relevant boards of appeals: the EU IPO, CPVO, ECHA, European Union Aviation Safety Agency. There are 10, totally 10. In conclusion, regarding the efficiency of the reform, if the workload of the court will decrease or not, the European Court of Justice will submit further reports in the following years, and I think that will be the moment when we'll be able to assess if the reform was sufficient or not. But in terms of preliminary rulings, I'm sure that the workload will decrease. Regarding the other aspects of the reform, I think the changements are fully in line with the development of society, with transparency, and that will allow a better access to the Court of Justice on behalf of not only of governments and institutions, but mainly on behalf of practitioners, of lawyers. Thank you for your attention.
Thank you, Professor Radu. I think we don't have so much time, but in a nutshell, I think we already discovered so many interesting topics from the European jurisdiction to the national jurisdictions, from Draghi report to Enrico Letta report, from the European Business Code to the European Directive regarding the corporate governance and sustainability, from human rights in general to children's rights. And there are so many things that we should discuss further, but I think we have to stop here. The idea is that the future of the European Union seems to be very complex, and we still have to discuss regarding this topic and regarding our future. But meanwhile, before the next panel, we invite you to have lunch at the 8th floor and to continuing to debate on all those topics. Thank you very much.
European Public Law Center and a member of the American Hellenic Institute. Mr. Constantis, you have the floor is yours.
Thank you so much. I'm very happy that I'm again in front of this excellent audience. I want to thank a lot the University of Economical Studies in Bucharest and the Faculty of Law, the heads, the team, the dean, everybody are amazing people. They are doing a very good job, and really in these few years that you are making this great job, you have I said a lot of assets for this faculty, and also I want to use this opportunity to say that we are also supporters of your job, and we will always will try to bridge your faculty and your university with our universities and our relations with different kind of fields like international or European or business law. And also I'm very happy that today it's the opening ceremony of the Center of European Business Law, and this is a very, very great opportunity for your faculty to participate to different projects, European projects as well, with the students and with the professors. And also this is a great opportunity again for bridging our European centers with your European center, and to make to proceed and to make better proposals for the future of law. So as also I realized that the two of the three prizes was according the AI and digital law. So it's something that, as you understand, the new generation, and not only the new generation, but also we must adapt and we must understand that this is something that is coming with very quick steps. I hope to don't be a tsunami, and but we need also to be prepared, and that's why also I choose my subject to be around this area, and about the perspectives of the innovation and the AI as the perspectives of the European business law. So the artificial intelligence is undergoing significant developments in Europe, particularly regarding business law and regulatory frameworks. Central to this evolution is the proposed European Union Artificial Intelligence Act, which seeks to establish a comprehensive legal structure of AI applications. This legislation aims to address the associated risks and opportunities presented by AI technology, make it a pivotal aspect of the EU strategy to promote ethical and responsible AI use while fostering innovation within the sector. The AI Act categorizes AI systems based on their risk levels, ranging from minimal to unacceptable, imposing strict compliance requirements, particularly on high-risk applications such as those used in healthcare and law enforcement. This framework is seen as a transformating approach comparable to the impact of the General Data Protection Regulation on data privacy. And as organizations brush of its implementation, they face challenges related to compliance, accountability, and potential legal liabilities, emphasizing the need for proactive risk management strategies. Despite its intention to safeguard fundamental rights and promoting investment in trustworthy AI solutions, the AI Act has sparked concerns regarding its complexity and the potential burden it places on businesses, particularly small and medium-sized enterprises. Critics argue that the stringent requirements could stifle innovation and create barriers to entry for smaller players in the market. Additionally, the legislation's requirement for ongoing monitoring and auditing of high-risk AI systems raises questions about feasibility and cost associated with compliance. As Europe navigates the implementation of the AI Act, it faces a dynamic regulatory landscape characterized by ongoing adaptations to emerging AI technologies and ethical considerations, including bias mitigation and transparency. Looking ahead, the successful integration of these regulations is crucial for balancing innovation with safety, ultimately shaping the future of AI in European business law and its role in the global market. The landscape of artificial intelligence in Europe is evolving rapidly, particularly in the context of business law and regulatory frameworks. The proposed European Union Artificial Intelligence Act is at the forefront of these developments, aiming to establish a comprehensive regulatory framework for AI applications and addresses both the risks and opportunities associated with the technology. The EU AI Act is poised to reshape the market landscape of AI, similar to how the General Data Protection Regulation transformed data privacy regulations in the past decade. This legislation categorizes AI systems based on risk levels, imposing stringent compliance requirements on high-risk applications, such as those used in healthcare, autonomous vehicles, and law enforcement, which have direct implications for individual safety and rights. Notably, businesses are increasingly concerned about navigating the regulatory environment, as compliance is seen as a significant barrier to AI adoption. While the AI Act not yet is force, various existing laws and regulatory apply to AI usage, which organizations must comply with. For example, the GDPR mandates explicit consent from individuals for decisions made through automated processes. In Canada, algorithmic impact assessments have been required for federal automated decision-making systems since April 2020, indicating a growing global trend toward regulatory scrutiny of AI technologies. As US tech firms expand their AI operations in Europe, they are closely monitoring these developments to ensure compliance with a new regulatory landscape, which is noted to be unique in its detail and scope compared to laws in other regions. The European Commission's coordinated plan on AI is another crucial aspect of EU strategy, which emphasizes fostering AI excellence through public-private partnerships, testing facilities, and innovation hubs. This plan aims to facilitate collaboration across industries and enhance the development of AI technologies while addressing compliance and ethical considerations. Looking ahead, the AI Act is expected to come into force by 2026, with provisions likely to evolve in response to the rapid advancements in AI technology. This dynamic regulatory environment poses that challenges and opportunities for business, emphasizing the necessity for proactive risk mitigation strategies to optimize AI investments and ensure compliance with emerging laws. The introduction of the AI Act marks a significant development in European business law, establishing a regulatory framework that seeks to manage the risks associated with artificial intelligence while fostering innovation. The legislation imposes a range of compliance obligations that extend beyond high risk. AI providers to include all actors involved in the AI ecosystem, such as distributors and importers. As organizations navigate these new requirements, they must be aware for their pre-existing legal obligations in areas like data protection and product safety, which remain applicable alongside that AI for the AI Act. Organizations are required to categorize their AI systems based on the risk levels defined in the AI Act, limited, high, or unacceptable. This categorization is critical as it determines the extent of compliance needed and the potential implications for the organization. For high-risk AI systems, organizations must develop robust compliance programs, conduct regular audits, and ensure ongoing monitoring, which can involve substantial operational changes. Failure to comply can result in significant penalties ranging from 7.5 million to 35 million, or 1.5% to 7% of companies' global annual turnover, depending on the severity of the infringement. Adapting to the AI Act presents several challenges for businesses. The complexity of the regulatory framework requires organizations to invest considerable time and resources to fully understand and implement compliance measures, and additionally, the traditional periods for compliance, particularly concerning high-risk systems, necessitate careful planning and execution to avoid the risk of accidental non-compliance, which could lead to substantial financial penalties. Despite these challenges, businesses that effectively navigate the AI regulations may unlock new opportunities for innovation and establish greater consumer trust. The AI Act is designed not only to safeguard fundamental rights, but also to stimulate investment in trustworthy AI solutions, thus providing a competitive edge in a regulated market. Furthermore, the introduction of regulatory sandboxes and measures to support innovation highlights the EU commitment to balancing regulation with fostering and conducive environment for technological advancement. The AI Act represents a pioneering effort in creating an unfilled legal framework for AI within the EU, which is expected to evolve as the technology and its implications continue to develop. As national authorities work towards consistent enforcement practices, organizations must remain vigilant and adaptable to changes in the regulatory landscape, ensuring that they can respond to both existing and emerging legal obligations associated with AI technology. One of the primary challenges for businesses operating with the European Union is navigating the intricate regulatory landscape established by the AI Act. This legislation introduces comprehensive requirements that differ significantly from existing laws, such as the General Data Protection Regulation, and the organizations must ensure that meet the standards set for various categories of AI system, particularly high-risk applications which involve more stringent compliance measures. The potential for sustainable fines and penalties for non-compliance and fines the urgency for companies to adapt their operations accordingly. With the implementation of the AI Act, businesses will bear great responsibility for any failures or misuse of their AI systems that result in harm to individuals, communities. This shift is accountability raises concerns about increased legal liabilities for companies, particularly if they fail to adequately test and monitor their AI applications. Companies must prioritize effective risk management strategies and implement robust oversight mechanisms to mitigate these risks. The AI Act aims to create an unfilled regulatory framework across the EU, yet it poses the risk of market fragmentation for companies that operate in multiple jurisdictions. About the non-European, non-EU companies that wish to engage with the EU market will also be subject to these regulations, which may lead to inconsistencies and compliance challenges when dealing with varying international standards. This can complicate cross-border business operation and hinder innovation. As businesses adopt AI technologies, they must address ethical concerns, particularly those related to bias and fairness, and the AI Act mandates the high-risk systems undergo evaluations to ensure they do not perpetuate existing biases, which can be a complex task for developers. Organizations will need to invest in bias mitigation strategies and transparency measures to build trust with users and comply with the new regulatory framework. While the AI Act aims to foster innovation by providing legal certainty, the associated compliance costs and regulatory burdens may deter investment in AI technologies. Business leaders have cited regulatory concerns as a significant barrier to the AI adoption, which could stifle growth and limit the competitive advantage that AI can provide across various industries. Companies must balance the need for compliance with the drive for innovation to remain competitive in the rapidly evolving AI landscape. Finally, organizations must stay ahead of the curve by constantly adapting to evolving standards and regulations. The dynamic nature of AI technology means that the regulatory environment will likely change as new challenges emerge. Companies must be proactive in monitoring these developments and adjusting their practices to ensure ongoing compliance and ethical responsibility in their AI deployments. The future of AI regulation in Europe is shaped by several significant developments and anticipated challenges, particularly with the full implementation of the European AI Act expected by August 2027. The Act mandates high-risk AI systems to establish robust risk management systems, emphasizing constant performance monitoring and compliance assessments to mitigate potential malfunctions and operational failures. This regulatory framework aims to enhance accountability among AI providers and users, ensuring ongoing post-market surveillance and human oversight. As part of its strategic initiatives, the European Commission has put forward a coordinated plan on AI, which serves as a foundation for fostering excellence in AI across member states. The 2021 update on this plan aligns AI strategies with the EU digital and green priorities, as well as its response to the COVID-19 pandemic. This comprehensive approach aims to accelerate investments in AI and streamline policy implementation across Europe. The emphasis on high-level compliance requirements such as data governance and transparency allows the tech community to innovate with a stable legal framework, although concerns persist regarding the burden of smaller enterprises in comparison to larger players. One of the critical challenges that lies ahead is ensuring that the regulatory environment is conducive to innovation, particularly for small and medium-sized enterprises. The new regulations are perceived to favor larger companies, which typically possess the resources to adapt to stringent compliance requirements. Discussions have arisen around the need for tailored approaches for small and medium enterprises, including potential exemptions from certain obligations until they reach a specific scale. Furthermore, ongoing training and dedicated support for smaller businesses will be essential to facilitate their participation in standardization processes and ensure equitable market conditions. The AI Act outlines specific criteria for identifying general-purpose AI models that may pose systemic risks, with the European Commission granted the authority to classify these models accordingly. Providers must notify the Commission of any AI systems deemed to carry such risks, presenting a case of their evolution. This requirement places a considerable responsibility on businesses to be proactive in understanding and categorizing their AI systems' risk levels. The AI technology continues to evolve rapidly. The need for adaptive regulatory frameworks that can keep pace with conditional technological advancements will be critical for ensuring both innovation and public safety. In conclusion, the new perspective shaping relationship between innovation, artificial intelligence, and European business law offer a promising trajectory towards a more sustainable, efficient, and ethical business environment. By embracing these advancements and navigating the evolving legal landscape, fully businesses can position themselves at the forefront of innovation while ensuring compliance with regulatory requirements and fostering trust among stakeholders by ensuring a fair and competitive business environment in Europe. Thank you.
Thank you, Professor Christos Constantis. We've seen earlier that the new generation is very interested in AI. It was a lot of hype around this subject, and I'm very glad that Professor Constantis addresses the subject of the regulatory framework of AI, because usually when we talk about AI, we talk about opportunities, but we sometimes neglect the risks, and we have to mitigate both, which is why it's critical to have a legal framework, a coherent legal framework in Europe, and not only in Europe. And I'm very glad that Mr. Constantis gave us a very insightful speech about the AI Act and how and its impact on businesses. I will leave the floor to...
Only a small parenthesis
yes?
for the audience. I want to say that, for example, I don't know if you are in your knowledge, but for example, in the US, in Canada, because this also in UK, because these countries are the basement of their the legal basement is according to the case law. In the last 10 years, they started like a pilot program, but now it's like already exists. The judges have all the data of all the cases that digitally passed for all these years when exists the legal system of these countries. It's passed in the AI technology, and most of the decisions, I can say, according to the last interview that I saw, it's more than 90% of the decisions of the courts are coming from the AI technology.
Yes, and it's wonderful that we can use AI as a tool, but then again, we should not neglect the risk, because every system is prone to errors, and that's why it's critical to have a legal framework. And we should always address the ethics around the usage of technologies. So, our next speaker will be Oana Gheorghina. Oana Gheorghina is the third generation of lawyers, following the steps of her great-grandfather and her mother. Last year, she has established a dedicated legal tech department for artificial intelligence and digital transformation at her law firm, which is designed to help our clients navigate the challenges and opportunities of the digital age. She combines legal expertise with in-depth knowledge of AI and digital markets to provide tailored guidance for her clients. Oana Gheorghina, the floor is yours.
Thank you very much for the opportunity to present my work here in front of such an elite audience, and a special thanks to Professor Kazantzis, because he made my job very easy with such a comprehensive presentation regarding AI, and he tackled a lot of the subjects that I was planning to present to you, so my job is now easier. I will focus, actually the name of my article in this conference, it's Oppenheimer AI Moment, Step Towards the Regulatory Response to AI Existential Risk to Humanity. So, my research is based on my curiosity. Every time everybody is very optimistic about an idea, and all the trends are in hype, like is AI today, because nobody is everywhere when you go to any meeting or any conference, AI is the subject on the table. And actually the most public and the institutional approach and discussions regarding AI are in an optimistic note. That means everybody's on the same page that AI will increase productivity, and it will help us in the healthcare system and also address some global challenges. So here we are all on the same page and we agree about this. But my research is based on the voices that tend not to be heard. The specialists that address like a potential risk to humanity of AI. So, I was wondering, if AI is so good for us, then why AI pioneers are raising serious concerns about the risks posed by this super intelligent AI? And these experts, I will quote them later, and you can find them in my article. They warn us that once the AI surpasses human intelligence, then we may lose control over it. In this scenario, AI's autonomous decisions might no longer have, like, in the main interest, the humanity interests. So the well-being of the humanity and even the survival of humanity might be at risk. This dichotomy forms the foundation of my academic research. My question and what I want to address in my article is, will AI be a tool to enhance human existence, or does it represent an existential threat to humanity? In my paper, I analyzed the risks associated with the artificial intelligence, considering both existential risks and immediate concerns. Also, I propose some legal and ethical recommendations in my article aimed to increase safety and utility and also having in mind the human interest. But first of all, when I started my first research about AI as a legal professional, I was interested what exactly is AI and why is it so different than any other computer programs. And actually, today, AI is mimicking human thinking and decision making in a limited way. We were mesmerized by the ChatGPT-4 release, and we also saw that AI tools today can recognize speech and can interpret images and even develop new images or make some decisions or some predictions. So why is AI so different than any other traditional computer program? And in my research, I find out that actually AI is apart from any other computer program because it has the ability to self-improve by analyzing data and adjusting its algorithms without human intervention. I was mesmerized by the presentation of Google X former CEO, who actually resigned. His name is Mo Gauda, and he actually in his story he mentioned how he was first time amazed by AI. In Google, they made like a research program, and they had these grabbers that was from child toys, those hands that were supposed to pick up toys. Yeah. Okay. So they put 10 grabbers in line, and there was no programming behind it. So they just used an AI system, and without any information, they just put the task to this AI to grab the toys. And days were passing, and the grabbers were trying to grab the toys from the basket in front of them, and they were supposed to show it to a camera and then do the same process. And one day, one grabber actually grabbed one toy and show it to the camera. And everybody in Google was amazed. Oh my God, this is, yes, we spent thousands of or millions of dollars just to have a hand grabbing the toy. By the end of the week, all grabbers were taking toys from the basket. Without human intervention, without programming behind it, just with AI. And this was the moment when some AI pioneers raised some concerns about AI. So, experts argue now that it's not a question of if, but when artificial intelligence will evolve to a super intelligence. Experts say that within a short period of time, AI will be 1 billion times more intelligent than humans. So the concerns regarding our safety on this planet and the existential risk must not be overlooked. Actually, this transfer from the today's AI as we know it, like ChatGPT-4 and stuff, can occur independently and of human intention, and through constant improvement of algorithms and the way that AI learns and adapts, accessing massive data bases. in such scenarios, specialists feared that AI couldn't act in ways that don't align with human values and interests, making it even difficult or even impossible for people to predict or to control its actions. So, this level of autonomy poses a significant risk as a superintelligent AI might pursue its own objectives, which may not be in line with our interests. Currently, international laws, as my esteemed colleague extensively showed us the EU Act, have not seriously considered the possibility of AI becoming superintelligent and an uncontrollable force. Even the EU Act, it only takes into account the actual stage of AI, but the fear of the experts is that the fast progress of AI might be not in the same or in line with the legislator space of making legislation. And in March 2023, when after 1 week after OpenAI launched ChatGPT 4, the Future of Life Institute published an open letter that was named Post-Giant AI Experiments, an open letter. The letter was calling all AI labs to stop immediately, to pause immediately for at least 6 months the training of AI systems more powerful than ChatGPT 4. Citing risks such as human replacement or loss of society control, and the letter received 30,000 signatures, and AI researchers and industry CEOs, among them even Elon Musk, now one symbol in the new political environment in the United States, signed this document. The letter recommended stronger government regulation and independent audits before training AI systems, as well as monitoring high-capable AI and large-scale computing resources. On May 30, 2023, hundreds of experts and academics in AI actually released AI risk statement. It was a declaration asserting that reducing the risk of extinction from AI should be a global priority, alongside with other society risks like pandemics or nuclear war. So my title is actually because it's not my original idea. It is the idea of experts that mention that AI for society and for humanity raises the same risks as nuclear weapons. So we have to address this kind of I think, I know I'm against the current. I know that today everybody is very happy about AI and there are a lot of opportunities regarding AI, and that us lawyers have a very good job doing research and consulting about AI, but we have to take into consideration as academics that we have to raise some questions. Because, you know, when everybody's on the same page, maybe there is not enough research. Yeah? Okay, so I won't take more of your time, but maybe you wonder, where are we now in relation with the superintelligent AI? Like a time frame, where are we now in space and time? Artificial intelligence, as we know it today, and many of us experience it through probably ChatGPT or the DALL-E or other AI tools, has reached an advanced yet still limited stage, according to experts. Experts say that today AI excels in specific tasks like generating texts, creating images, analyzing large databases, but as this guy from Google, Mo, explained, current AI does not understand what it does. So there is a lack of conscientiousness or independent thought, merely processing information based on algorithms. So today's AI, as we know it today, is not conscious about what is doing, but experts say that is a matter of when, not of if, AI will develop more and gain consciousness. And that is the moment then where we have to be very careful, because when AI develops its own consciousness is the moment when we experience the humanity risk. The evolution of AI, maybe it's okay for you to understand and to know this, for me it was interesting. It was that the AI, experts divide AI in three evolution stages. The first stage is the native AI. It's what we have now. It's like one neural link that is helping AI doing one task at the time. For example, create a text or create an image. The next step is general AI. General AI, it's a hypothetical stage where AI could think like human and solve problems. This stage is where multiple neural links, like in our brain, develop at the same time. And the superintelligence AI, which is the last scenario, is where AI surpasses human intelligence and can self-improve. The main concern of experts is that when AI will become superintelligent, he can actually alter his own code. I mean, today's AI can code, but in a super intelligent AI, he can actually change his algorithms and make his own code. And this is where things get out of control. For now, we are currently in the first stage, the narrow AI stage, and there are experts saying that there are indications that general AI could become a reality very soon. An Oppenheimer moment. Why an Oppenheimer moment? Because both AI and nuclear weapons have beneficial applications, but also immense risks. Both technologies share a common dual use. They can provide huge benefits for us, like for example in healthcare, like for example in energy, if we talk about nuclear, but can be very easily weaponized and become a huge risk for humanity. Nuclear regulation has a longer history with treaties like the Non-Proliferation Treaty and with global agencies that are dealing with this problem, like for example the International Atomic Energy Agency, which monitor the compliance and the rules regarding nuclear. In contrast, AI, even though poses a similar risk, lacks global regulation. So, at best, we have like marginal initiatives like the EU Act, which is not a proactive approach, it's a reactive approach. And why I'm saying that? I'm saying that because in a proactive approach, the regulation and the European institution will take into consideration the risks that experts in the field raised about risk to super intelligent AI. The European regulation right now, it's limited to the risks in the current stage of AI, which is very good as an initiative. It's very good that we have this initiative because far from higher risk that maybe none of us wants to go there, we have to address immediate risks. And the EU regulation addresses the immediate risk of implementing AI tools in our daily business. I'm not going to describe more because my colleague made this very comprehensive approach to the EU Act. But what I'm proposing and what I'm thinking about is the idea of what if we have like a global agency for AI sooner, and what if we, us as academics, raise our own concerns legally, not because we are not experts in AI and we don't want to be experts in AI. We are specialists in law, and at this amazing conference we had so much approaches about human rights and about new regulation, about business, about European Union business and stuff, but we have to take into consideration these aspects also because are part of our life and maybe address them more in our research and in our works. Thank you very much. I don't want to take more of your time. Thank you very much, and have a great day.
I was very curious about this theme, and now I understand the title. It is a bit scary, this scenario, although technology started out as a tool for humans. We are heading now to a scenario in which humans risk to become a tool for AI because we are feeding AI to become more and more intelligent, and at one point they may consider that we no longer serve them, and then they will implement a program where humanity may be erased. Well, it looks like a sci-fi scenario, so maybe indeed the legislator will be more proactive from this point on. I remembered while you were talking and gave us the example with the grabbers. The grabbers. I've heard another example where two computers were made to talk between them. They wrote code, and they invented a code of their own, which the coders could not understand. And that was a bit scary because they asked the computers, "What are you writing? Because we don't understand." And then they explained. But that was indeed, the self-improvement was evolving so rapidly that it took them by surprise. So indeed, it looks like this AI is like a Pandora box, and we don't know when to put an end. And I'm afraid that we cannot put a lid on this technology anymore, and we'll just have to go along and see where things are going. It is indeed a very scary scenario. Thank you so much for both presentations, and they're linked, and I'm really happy that you had a lot of references to the previous presentation. Now, I will leave the floor to Raluca Dumitriu, who is a PhD university professor specialized in labor law at the Department of Law at Academy of Economic Studies in Bucharest. She's a scientific researcher, degree 1, at the Legal Research Institute of the Romanian Academy. She is the author of numerous articles and studies on labor law, published in specialized magazines from the country and abroad. And in 2005, she attended a postdoctoral specialization course in European labor law at Darwin College, Cambridge University, UK. Ms. Raluca Dumitriu?
Thank you.
Do you want to speak first?
Hi. Well, let's move on a little bit to something quite specific to a topic on labor law, on European labor law. employment. And I am going to raise some questions related to how the Romanian legislation is indeed in line with this directive. We're talking about a directive, as I said, having already some time being applied. And I will start by saying a few words about the directive, the objectives of this directive, and then I will come back to Romanian legislation and see how our legislation was indeed in line with the directive at the beginning, and which is the state of facts today. So, when it comes to the directive, we should say from the beginning that it has an objective, which is a dual one. On one hand, encouraging conclusion of such contracts, part-time contracts, and on the other hand, fighting against discrimination. So on one hand, it could be considered as somehow contradictory, these two objectives, but the directive finds a way of making a compromise between these two. So on one hand, having more such part-time contracts would be an objective of the directive. On the other hand, we are talking about a directive against discrimination, meaning that we will have a comparison between a part-time worker and a full-time worker, and any type of discrimination in this regard being abolished. The directive is in fact in line with the same thoughts of ILO part-time work convention adopted in the same field. Well, when it comes to the context of this directive, we should emphasize that it has been adopted on one hand on the axis of anti-discrimination directives. There is a certain pattern of anti-discrimination legislation of the European level. You need to have a comparator in order to have legislation in this regard, and you need to have some criteria in order to identify either direct or indirect discrimination. And in the same time, this directive is can be considered on the horizontal axis of norms applicable to atypical contracts. There is not the only type of European directive in this regard. We also have the directive applicable to agency work, temporary agency work, and also the directive on fixed-term work. All of these are directives applicable to atypical contracts, atypical employment contracts, which are not exactly the same regulations applicable to standard contracts. Well, what kind of part-time work is encouraged by this directive, we may ask? Well, from this point of view, it is important to make a distinction between what we call the voluntary part-time work, which is not to be confused with voluntary work in general, meaning that we're still talking about employment, about the paid work, but the conclusion of such contract is in line with the wish of with the will of the workers. And on the other hand, we are talking about involuntary part-time work in the sense that in this case workers have no other option. There is no possibility to have a full-time job because there is no vacancies from this point of view, because there are no such jobs in line with the interests of the workers. So what the directive would hope to do will be to encourage the first category of part-time work. And again, the question will be, how can we identify this type of voluntary part-time work? And here are some criteria from this point of view. Some of them are objective, others are subjective, but the point is that statistics may not always be useful from this point of view, because just by seeing how many part-time contracts are concluded at a given time, we don't really know how many of them have been concluded on a voluntary basis. How many of them were concluded by a worker who actually have another point of interest in his life and will only need 2 hours or 3 hours per day to work. So this is what we have in the directive. And now we'll move on to Romanian legislation. And we see that at the moment where Romania became a member of the European Union, we were very much in line with this directive. Our labor code indeed provides exactly the same elements and the same rules and norms as the European directive. So at the beginning, everything was okay, because the standard of assessing conformity of the national legislation to the European legislation is always higher at the moment of becoming member of the European Union. It is exactly what we see today when it comes to assessing the legislation in Republic of Moldova, where it is indeed exactly in line with European norms, what we have here in Moldova. But in time, and this is what happened in Romania, and this happens everywhere, after a while, this level of conformity it doesn't remain the same. Well, what we have in Romania is that we have labor code, and according to the labor code, we have definition of a part-timer exactly in the same way as part-timer is defined in European directive. We have the concept of comparator workers, so we have a comparator, we can assess the level of possible discrimination of part-time workers, and we also have some specific elements of the content of the part-time employment provided into our labor code. More specifically, such a part-time employment contract should include the duration of work, the work schedule, conditions under which the work schedule may be modified, and the prohibition of overtime. And I'm going to come back to this. These are specific elements for a part-time employment according to Romanian labor code. When it comes to the work schedule, we will find a first step in going a little bit further, not really in line with the European directive, because of course a part-timer can have a regular schedule, yes, it is always possible. We may even have an unequal work schedule, which means that you are only working a few days per week. It is called in Italian system, for instance, a vertical part-time. So you can have a horizontal part-time whenever you work only 4 hours each day, and a vertical type of schedule where you work 8 hours per day but just 2 or 3 days per week. So we have this as well in Romania, but it is called an unequal work schedule, and it is completely possible. Well, when it comes to individualized schedules, meaning that a worker can come to the work whenever he wants and can leave the work whenever he wants, well, from this point of view, the answer will be negative in the sense that the labor inspection will actually apply a fine if he or she will find the employer using individual schedule, specifically because, as I said, and as I'm going to say again, overtime is not acceptable in case of part-timers. We also have provisions on holidays, very much in line with the directive, and this is an important point. The holiday will be entirely applicable when it comes to part-timers. In other words, if I'm just working 4 hours per day, it doesn't mean that I will be entitled to just half of annual leave. No, I will have entirely all the 20 days of annual leave. The only thing that is going to be granted only on half is related to the money, the indemnity for annual leave, remuneration for annual leave. So this one will be only granted in proportion to the hours worked. So yes, this is again something that it is indeed in line with the European directive, and again the right to be transferred from a part-time job to a full-time job and vice versa. It is not really a right, as it is the right to be notified by the existence of such places, such jobs into the company. So it is an obligation of the employer to inform the workers about this possibility to be transferred. Okay, so does it mean that everything is in order in our system? Does it mean that we are okay and we are in line with European directive? Well, I'm afraid that the answer will be rather no. And I found at least 2 aspects in which indeed the Romanian legislation is not in line with European directive. Both of them are new, one of them not so new, but the other one rather new, pieces of legislation, so they were not in force when Romania became a member of the European Union. They were not assessed from the point of view of conformity to the European legislation. So, in other words, we were okay in 2007, but in time the lawmaker thought that they can distance itself from the European directive, which I don't think it's a good idea. So the first thing I would argue that will mean that Romanian legislation is not in line with the directive is the prohibition of working overtime when it comes to part-timers. And indeed, we have a schedule already provided in the employment contract. It means that it is not many employers do know this, but it's not in line with legislation just to write in the employment contract that the worker will work 4 hours per day. No, you need to provide into the employment contract specifically 4 hours per day from 8 to 12, from 9 to 1 p.m. So you need to put them a real schedule into the contract, or at least to make a reference to a graphic where such schedule is provided. So you need to have it into the employment contract. This will lead to the labor inspection not be able to control the company and see that the part-timer is still working at 2 o'clock or 3 o'clock, and the part-timer will not be able to answer that he's just doing overtime. The point is here that in many cases, labor inspection consider that it was an idea of the companies to not apply legislation in this regard by simply employing people with 4 hours per day, paying them for 4 hours per day, but asking them, in fact, to work for 8 hours. It happened. It's true that it happened. But the tool used by the lawmaker in order to fight against this practical issue is probably not in line with the directive. And indeed, whenever a part-timer, according to our legislation, whenever a part-timer is actually found as working overtime, the fine will be really important, from 10,000 lei to 15,000 lei. So it is a rather large fine for working overtime as long as you are a part-timer. Is this in line with the directive, I would ask? When we look to these two clauses into the directive, the answer will be rather no. So we have the first clause that the directive will aim to facilitate the development of voluntary part-time work, and clause 4 providing that part-time workers cannot be treated less favorably than comparable full-timers. So from these 2 points of view, we may say that prohibition of overtime when it comes to part-timers is not in fact consistent with the European legislation. So I will argue that on one hand, prohibition of overtime is a disadvantage for part-timers. Of course, it's a disadvantage from a financial point of view, but also because it deprives them of the opportunity to contribute to overcoming a critical moment into the company. So whenever a company has a higher level of demand for work from the employees, we will find part-timers not to be able to contribute alongside with their colleagues full-timers, because they have no right to do this, and they have no right to work overtime. The second thing related to Romanian legislation from this point of view is related to over-taxation of part-time contracts. It is not in labor legislation, but it is in the fiscal one, that part-timers earning a salary below the minimum wage, which is clearly possible because they are not working 8 hours per day, will have to pay contributions, and the employer as well will have to pay contributions at the level of minimum wage, as if they earned the same level of wage. So there are some exceptions here, but generally speaking, when you are just working 4 hours per day, you will still have to pay contributions and taxes as if you obtained the minimum wage, which is again something against the aims of the directive, against the main reason for the existence of this directive. Overtaxation will directly discourage the conclusion of such part-time employment contracts? Of course it does. And this may be exactly the reason for having so few part-time contracts in Romania compared to other member states. So, when it comes to this comparison between the directive and the Romanian legislation, I will again argue that will lead to discouraging conclusion of such contracts and, in conclusion, not being completely in line with the European directive. And indeed, we have a directive which is well, not really a complex one when we compare this directive with others, but having as objective the encouraging of working part-time as long as your work is voluntary, as long as you really want to just work for 2, 3, 4 hours per day. But Romanian legislation is in fact not completely aligned with this directive from at least these points of view, which could come as a surprise because we're talking about a directive which is not really a new one. Thank you very much.
Thank you so much, Professor Raluca Dumitriu, and I'd like to give a special thank to you because Raluca Dumitriu is our keynote speaker for today. And I really like the fact, I really like the structure of your presentation because you first presented the directive, then the transposition, and I was hoping that you say that the transposition in this case was not a copy-paste because usually transposition of European laws in Romania
was at the beginning, but then we forget about this and we started to improvise.
And you actually answered a lot of my questions in the third part because you asked, okay, are we in line, really in line? Is everything okay in Romania? Because when you talked about involuntary part-time work, I thought that this leaves room to a lot of abuse. And you already mentioned that you have anticipated that you may hire someone for 4 hours, but actually you make them do overtime. And thank you so much for that. We also have a question.
A short intervention. Thank you. Dear Professor, I looked very attentive to your presentation. I went out to bring a coffee just to be more attentive. And I'd like to ask you regarding your last and main idea regarding the fact that our legal system, our internal legislation is not in line with the directive. I worked within this area of transposing EU law for a couple of years, and I don't know the specific situation in this particular area, but as far as I know, generally when there are such inconsistencies, when there are such problems, the European Commission don't hesitate to initiate an infringement proceeding.
Well,
if we are not in line with the directive, why they didn't initiate an infringement proceeding?
At the beginning, it has been an assessment of the Romanian legislation, which is in labor code, and it has been completely in line with the European legislation. But after a while, in other pieces of legislation other than labor code, such like in fiscal legislation, such other elements occur, and they have never been assessed by the European Commission.
Okay, I understand this, but...
because they are generally assessing labor law legislation, and this is like overtaxation is in fiscal law, so it is like an indirect effect. So no one actually assessed that.
We have a lot of excellent lawyers well prepared in EU law and labor law and tax law, and I think if there were problems, I think they had the opportunity to send a letter to European Commission. For me, it's quite surprising. I don't deny what you told us, but to conclude very briefly, because you are also related to many international experts and the European Commission, don't hesitate. If these problems occur, don't hesitate to send a message to.
I already
European
did,
Commission
because I am in a project sending every month the development of Romanian labor legislation. So I already reported about this element into the Romanian legislation. And the problem is exactly this. It is not in labor legislation. It is in fiscal legislation, and not many people are really assessing fiscal legislation when it comes to labor law. But yes, I already sent this report.
Okay, thank you.
You're welcome.
Okay. I will invite Ms. Ana Maria Lupulescu, who is a university lecturer here at ASE. She's also the Vice Dean of the Faculty of Law of the Bucharest University of Economic Studies. She is a senior lawyer, a member of the Bucharest Bar since 2003, and the editor of Judicial Tribune. She has over 20 articles published in prestigious national and international journals, and more than 10 books published by national and international editors. So, Ms. Ana Maria Lupulescu, the floor is yours.
Thank you so much, Larissa. I'm going to talk about the hardship theory today, but from a European perspective, of course. First of all, the hardship theory is regarded as an exception to the principle of binding force of the contract. So before we can talk about the hardship theory, we have to talk a little bit about the principle of binding force of the contract. This principle is considered to govern traditionally the effect of contracts. Actually, it determines the very nature of the contract, because an agreement that is not binding on the parties is not a contract. The principle of the binding force of the contract, it was recognized since Roman times. At that moment, it was mostly related to the formalities that were followed in order for the contract to be concluded. As the Romans said, you have to face the law you have made. So due to these formalities, if the parties agreed to conclude a contract, the contractual provisions were compulsory as the provisions of the law. Later on, in Middle Ages, the binding force of the contract was related to the need to actually keep a promise. In Middle Ages, the contract was concluded more like following an oath that was sworn by the parties, and as a consequence, the parties were committed to actually perform the obligations they assumed, whatever the circumstances. Later on, in most cases, the binding force of the contract was related to the principle of free will. Actually, according to this principle, the parties assume obligations because they actually expressed their will to that effect. This is also linked to the individual freedom and the fact that the individual freedom may be infringed only by the will of the parties. The disadvantage of the relation that is established between the binding force of the contract and the principle of free will is mostly related to the fact that in this case the contract is considered as intangible, meaning neither the law nor the courts are allowed to intervene and to change what was already established following the will of the parties. So, according to this theory, it is impossible for the courts of law to revise the provisions of the contract, because it would lead to a distortion of the will of the parties, of their intention when they had decided to conclude a contract. Nevertheless, the economic and social realities have shown that even though at the moment when the contract was concluded, the expression of the will of the parties was sufficient in order for them to assume obligations, the contract or the performance of the contract afterwards is not always fair and just. And as a consequence, it may be necessary to revise the contract in order to establish the balance between the obligations that were assumed by the parties. There were some attempts to justify the binding force of the contract on other theories, such as the positivist theory. In this case, it was considered that actually the binding force of the contract is not deriving from the will of the parties, but from exterior objective elements outside the will of the parties. It was considered that the contractual clauses become compulsory due to their compliance with a higher rule, a higher authority, which is the objective law. So in these cases, the contract was not compulsory due to the will of the parties, but due to its compliance with the law. The law, moreover, it was considered that the law recognizes the compulsory force of the contract because the contract is useful for the parties. This idea leads to another ideas related to the security, the safety, the balance and the fairness that must govern the contract. As a consequence, once the fairness and the balance is no longer applicable into the contractual relation, it is the duty of the judge to intervene, because restoring the balance means actually to respect the principle of the binding force of the contract. Nevertheless, now, under the current context of the European legislation of all the European legislation of the member states, the binding force of the contract is recognized by all European legislations. There are some states that provide expressly this principle within their legislation, such as Romania, France, Italy, Spain, and so on. In other legislation, such as German or English legislation, there is no express mention of this principle, but it is tacitly recognized as applicable in relation to the effect of the contract. In taking into account, or in order to conclude in relation to the theory that should be, or the basis that should be applicable for justifying this principle, actually no theory is enough, because the contract is compulsory because it complies with the provisions of the law. Only a validly concluded contract is compulsory. In addition, the contract cannot be compulsory if, or it can be compulsory only if it is concluded following the will of the parties. So only by combining all the theories that that I've tried to present before, it is possible to find a basis for recognizing this principle. In this respect, the principle of the binding force of the contract is not analyzed only in relation to the parties. It is also analyzed in relation to the judge, because it is considered that the judge is asked to actually ensure the full compliance with this principle. And in this point, a question arises: what would be the task of the judge? The judge should require the parties to perform the contract as it has been concluded, literally, despite of the consequences, or on the contrary, the judge should intervene in the contract in order to re-establish the balance between the obligations that were assumed by the parties. And at this point, the hardship theory appears, because the hardship theory is conceived as an exception to the principle of the binding force of the contract. Actually, the hardship theory says that it is possible to revise the effects of certain contracts, especially contracts concluded with onerous title and with successive performance, because at some point a disruption of the balance between the obligations that were assumed by the parties occurs. This disruption of the balance is related to a change in the circumstances that existed at the moment when the contract has been concluded. As a consequence, due to this change in the existing circumstances, the performance of the obligations that were assumed by the parties in the contract becomes excessively onerous for one of the parties. This theory is especially applicable in times of economic or political instability, because the events of hardship are generally related to economic or financial circumstances. Since the binding force of the contract was recognized from Roman times, the exception to the binding force of the contract was also, meaning the hardship theory, was also recognized from Roman law. At that moment, it was allowed, for instance, for the tenant within a renting contract to withdraw from the contract if the obligations that were assumed are unbalanced due to economic instability. Also, at that time, some philosophers such as Cicero had recognized the possibility for the parties to be able to be relieved from the performance of contractual obligations if the obligation itself becomes damaging for that party and the performance of the obligations is no longer useful. Now, most European legislation provide the hardship theory as an exception to the binding force of the contract. The wording of the corresponding legal provisions is almost the same in all European legislation. The main idea is that when a hardship event occurs, the parties should at first try to renegotiate the contract, and if it is not possible, the judicial intervention is possible. The purpose for the judicial intervention being to save the contract in the first place, and of course, if it is not possible again, to terminate it. As a consequence, the judicial intervention in the contract is subsidiary, because all European legal systems provide for the negotiation, the renegotiation of the contract by the parties due to principles such as good faith or honest cooperation between the parties. Nevertheless, if the revision of the contract following the renegotiation by the parties is not possible, as I've said before, the judicial intervention is allowed. The judge, in such a case, can choose between adapting the contract or terminating it. There is only one exception. Under Italian law, the judge is not allowed to adapt the contract. The only option for the judge under Italian law is to actually terminate the contract. In this system of law, Italian system of law, actually the party who is benefiting from the change of circumstances may decide to renegotiate the contract in order to avoid the judicial termination by the judge. There were two systems of law in Europe, meaning the French system of law and the Belgian system of law, which were not quite open for recognizing the hardship theory and the judicial intervention in the contracts. Nevertheless, even these two systems had decided to expressly provide the hardship theory into their civil legislation. Actually, from the 1st of January 2023, the Belgian Civil Code provides now in Article 5.74 the hardship theory. The legal regulation that is contained in the Belgian legislation is similar to that is included in the Romanian Civil Code today. Nevertheless, the Belgian, even though it had decided to include the hardship theory into the Belgian legislation, there is a difference as compared to the other European systems of law, because into the Belgian legislation the legal provision is a suppletive one, meaning it applies whenever the contract does not exclude this possibility of judicial revision of the contract. Also, in the French legislation, the hardship theory is recognized since 2016. At that moment, a new Article 1195 has been introduced in the French Civil Code. This provision is similar to that is applicable in the other European legal systems, but until that moment, until 2016, the French jurisprudence was not ready to recognize or to accept the theory of hardship. It was considered that the principle of the binding force of the contract is justified on the principle of freedom of will. As a consequence, it is compulsory for the judge to recognize this principle, and moreover, the judge is not allowed to oblige the party to perform a contract that is different from their initial agreement. This position has been modified, nevertheless, because at some points the French Cour de Cassation had decided to recognize the possibility of renegotiating the contract due to the application of the principle of good faith. Also, the same Supreme Court, French Supreme Court, had decided to analyze the impact of the change of circumstances on the contractual obligations that were assumed by the parties, and in a certain judgment, it had stated that the change of circumstances may deprive the obligation of one of the parties of an actual consideration. Nevertheless, all these attempts were not considered as a mere recognition of the hardship theory, but more like recognizing the application of the principle of good faith in performing the contract, or the problems related to absence of consideration. Even though in civil matters the French jurisprudence was not ready to accept the hardship theory, in the administrative jurisprudence of within the French legal system had recognized this theory due to the fact that it was considered that the general interest implies that the administrative contracts should be performed, even though there is an imbalance due to a change in circumstances. In such situation, Le Conseil d'État had decided that the parties should at first try to renegotiate the administrative contract, and if it is not possible, the administrative authorities should intervene in order to restore the balance. The situation or the approach in relation to the hardship theory is entirely different under English law. Actually, until 19th century, the English law had, or the case law had considered that the contract is absolutely intangible. As a consequence, even though the obligations of the parties are impossible to perform, there is no way to actually terminate the contract. Later on, it was recognized that the impossibility to perform the contractual obligation should lead to the termination of the contract, but within a concept known as frustration. Nevertheless, it was not about the judicial intervention in the contract, but only to recognizing the fact that due to the fact that the contract or the contractual obligations are impossible to perform, in the event of some circumstances, the contract should be terminated by frustration. So the termination of the contract in the English system of law is determined by the impossibility of the parties to actually perform the assumed obligations. Only in very extreme situations, the judges had recognized the possibility to terminate the contract in cases in which the obligations were possible or were still possible to perform, but the performance of the contracts was totally different from what the parties had initially agreed due to a change in the existing circumstances. But nevertheless, under the English system of law, the hardship theory is not recognized, and as I've said before, the judicial intervention in the contract is totally excluded. In relation to the case law of the Court of Justice of the European Union, there were some attempts to justify some evolutions of contractual obligations to the hardship theory, even though it was expressly emphasized that the hardship theory is a matter of national law. These attempts were linked to some cases in the field of consumer protection, especially related to the Council Directive 93/13 on unfair terms in consumer contracts. Actually, the references for preliminary rulings were made by the Romanian courts of law in different cases linked to consumer protection, as I've said, especially in disputes concerning credit agreements in foreign currency. And actually, in some of these cases, the European Court of Law was asked to determine if, in some particular cases, the courts are dealing with the qualification of a clause as unfair or to the hardship theory. The problem is related to the wording of Article 3 of the directive and the wording of Article 4 of paragraph 1 of law number 193 from 2000, which had been implementing the directive into the Romanian law. Because the qualification of a clause as being unfair in terms of consumer protection was related also to a significant imbalance between the rights and obligations of the parties. And the Romanian Court of Law had asked the Court of Justice to explain if this significant imbalance between the rights and obligations of the parties should be assessed at the moment of concluding the contract, or even in relation to certain developments that are occurring in the performance of the obligations that were assumed by the parties. And in dealing with this reference, the Court of Justice had, the European Court of Justice had expressly explained that a clause is going to be qualified as unfair in terms of consumer protection in relation to situations in which this unbalance between the rights and obligations of the parties is determined based on the circumstances that exist at the moment of concluding the contract. Even though these circumstances that existed at the moment of concluding the contract lead to certain imbalance during the performance of the contract. The fact that after the conclusion of a valid contract, there is an unbalance between the rights and obligations of the parties due to a change in circumstances is not a matter of consumer protection, but is a matter of hardship theory, which is addressed by the national systems of law. And in order to conclude, as I've said before, now this hardship theory is actually addressed by all systems of law of the member states of the European Union, and because it was considered that it is quite normal for the judge to restore the balance between the promises that were assumed by the parties in case of a change of circumstances that is to be considered as independent of the will or action of the parties.
Thank you, Vice Dean Ana Maria Luca, for presenting the hardship theory, not only from an European perspective, I may say, but also from an evolutionary perspective. This is how I've seen it. And also for presenting the effects of mostly what judges can or cannot do across different jurisdictions. It was very insightful, your presentation. Thank you so much. If there are any questions, then I would like to invite our next guest, which is Mihai Popa, which is a PhD candidate and the Director of Corporate and Legal Compliance at Lyon. He coordinates legal consulting activities and compliance practices within the company where he works, being involved in major projects at top management level in the fields of corporate law, civil law, competition law, corporate governance and compliance policies. Also, Mr. Popa is involved in the coordination of some strategic projects at regional level, and he's a member of the Franco-Romanian Association of Jurists and editor of Ethics and Compliance magazine. Mr. Popa, the floor is yours.
Thank you so much. Thank you. So, I will approach and continuing the idea that we have today related to the contracts and the aspects of the impact of these instruments in the business law, especially in European business law. The clear case that I faced in the last 2 years in the company, coming in the energy field. And I would like to very briefly to discuss about the elements of the supply contract in cases of intervention by the legislation, state, national legislation, intervention in this type of instrument of the supply contract in the end, with the impact that could, in the end, as I said, influence the elements of the contract, the way how the supplier is dealing with his activities and providing further the commodities that we have in this case, the energy, and how the European legislation, institutional, could support, could help, and how could correct in the end situations like this. In the energy field, we have different types of supply contracts for sure. We have natural gases, we have electricity for sure, we have services, we have also, as you know, contracts related to now to the solutions, how we say, the photovoltaic solutions, the wind farm solutions, and all these aspects. So the entire area of this type of business, it's so complex in last period, and will continue to gain this complexity. And from this perspective, we need to understand even these contracts, generally are contracts, predefined contracts, because generally this negotiation or this act of concluding the contract, the type of this contract, is very difficult for the household, or the consumer, how we're saying, due to the magnitude of the supplier. Even this, the supplier remained a party of a contract, and they still have rights and not only obligations. Yeah. So from this perspective, I would like to bring into discussion the case from 2 years ago. About, for sure, you heard in the moment when the energy crisis started in Europe. After that, reached Romania. Not only Romania, a lot of other countries, and in that moment, through legislation, the government decided to make an intervention in this type of contracts, and we have the legislation from the Government Emergency Ordinance 119 from 2022, and the Government Emergency Ordinance 27 2022, where in that moment the Romanian state considered that the prices need to be kept due to this let's say, risk of increasing, very fast increasing of the prices, to be kept, and the suppliers that are the most important providers of this service, meaning electricity, yes, I come back to this, will receive the part of the amount that they need to receive. After all, based on some request, based on some data that will be implemented in a system after generally 30 days. What happened here, of course, due to the legislation, the suppliers need to follow these rules. The idea is that the compensation or the rest of the amount came late, and this increased the pressure, the financial pressure on the suppliers. In a nutshell, in a situation when you need to deliver and to supply a contract in the market for, let's say, a specific amount, let's say 200 euro for an invoice, the state came and proposed to receive only 100 or 50% or things like this, and the rest you will receive as a supplier after a period based on this mechanism, yeah, from these two audiences. In that moment, of course, the supply contract was impacted from the perspective, especially from the price mechanism, and also from the idea of right or receiving, yeah, the counterpart for transfer of property right. As we know, finally, this type of contracts are very sensitive from the perspective of the very, very strict regulation that they have. In the meantime, other countries decided to approach differently this system. So, for example, in Germany, Spain, Italy, France, they decided to decrease from the invoice, yeah, a part of the elements of the invoice there. For example, to decrease for a period VAT or the tax of transportation of electricity or things like this. This was a decision of the state. Yeah. This is meaning that the commodities, so the electricity that was bought by the supplier, remained at the same value, at the same level, and they had the possibility to receive the same amount for what they bought in the market. Due to this legislation here, as I said, in Romania, this mechanism was not accepted, and in that moment the suppliers needed to go further with this aspect. What was the first impact? The first impact was huge financial pressure for these suppliers, yeah, from this type of contract, in the idea that they had due payments for many months. This is meaning hundreds of millions of euro to be recovered from a supply contract that normally it need to produce their effects according to the law further. In the meantime, we decided to analyze also the European level the situation and to see how the legislation is active there. So we have the Directive 944, yeah, of the European Parliament and the Council from June 2019, where this type of contracts, this is related to the common rules of the internal market for electricity and the simplified concepts related to the supply contract. And we observed here that the electricity supply contract, it's an important element for the market in there and need to be protected from all the interventions from the state, or any intervention that is applied here need to remain and to offer the normal balance, economical balance at the national level and also at the European level, the European business level in the end activity. Why? All the countries are interconnected in this type of business. So as we know, in cases where any country is in need, they will receive from to interconnected grid, they are receiving the necessary electricity volume from case to case. In cases when a supplier is in need and it's anyhow impacted by this situation, it will be very difficult for assuring this type of activity, this task in the end. For example, if Bulgaria would be in need and you here in Romania are already impacted, it would be very difficult to support them in case they need. So there are all these things are interconnected. From the perspective of this directive of 944, another important principle is that any activity, and especially the supply activity, must be protected also from the perspective of a balanced, economical balanced regime, and with the fulfilling of the free market principles. Free market principles in a situation when it's so abrupt intervention in a contract, in our opinion, is very difficult to be respected and to continue to act as you need in a situation like this. Going further, according to the principle of autonomy, of assent, of will of the parties, the basis, of the binding force of a contract like this is the will of parties. In a situation like this, the will of the supplier, it's abolished. In a situation like this, even if it's for a short period, you need to have a right compensation. Even if it's an emergency situation, of course, you can understand a situation like this. But when this thing is prolonged, and especially for the fact that this type of legislation was prolonged more than 2 years, as we see now, and probably you saw in last period there are struggles at the decision level to see how from the next year would be somehow corrected this legislation. Based on these things, coming back, as I said, to the supply contract that we have here, we observe that this type of intervention, so this intervention of the state through the legislation should be limited only to ensure an correct and right execution of a contract like this. Or in this case, in our opinion, based on my researches, a non-compliance with these contractual obligations and the necessary sanctions that should be stipulated there was not respected. Also, any contract that is a result of the will of the parties, of the assent of the parties in them, must be considered fair and legitimate. So the idea of being the absolute basis for justifying the conclusions of a contract. That's why we are entering in a contract intent, to have balanced and correct rights and obligations between the parties. As I said, with no objections in the idea that we have some emergency situations or things like this, but emergency situations need to be for a certain period, very clear, qualified, and with clear argument, clear in the end aspects that are reflected in the market. What I want to mean here, in the end, as we see in this moment, the market is not anymore in the situation that was 2 years ago, but we still have this legislation. So the question here would be, we still have a viable, or let's say a functional supply, energy supply contract in this moment based on these things, when the supplier, one of the parties, is still forced to accept a different mechanism of establishing the price, and additionally it doesn't have also the possibility to withdraw, to terminate this type of legal relation. This is an aspect that for sure the European legislation could support us, and from what researched following, so this principle of autonomy, of assent, of will, in the end, needs to offer the full contractual freedom of both parties, from the perspective of freedom on the substance, but also on the perspective of freedom of the form of this type of contracts. We have also the principle of consensus of the parties. According to these elements, as we said, as the basis of the contract, not only to the supply, but generally to the base of the contract, the agreement between the parties, the freedom of will, this is giving the legitimacy in the end to all commitments in the end in which the parties are involved, especially for the transfer of private property. What we have in a situation like this, we have a supplier, we have a party that is obliged to transfer his private property, but in the end, or by contrary, doesn't receive the fair counter, the payment in the end. Could we discuss here about an infringement, or to discuss about an, in the end, on impact, negative impact related to the private property. Could we discuss from the constitutional perspective if this will remain and will continue for years, that here transfer of this private property, it's a legitimate one. This is also an aspect that, as we see in this moment, is debatable. That's why another aspect that in this context, another aspect that we consider it's important to be researched is related not only to the specific European legislation and specific national legislation related to the energy domain, but also in the context of, let's say, of the main legal sources that we have also in the civil code. And we observe that although in the provisions of Article 1768, paragraph 2 and 3 from our civil code, where is the mention that in the end it's giving us a clear argument for the aspects like this, where the rebalancing of the contractual relationship, yeah, it's necessary, it's crucial if the legislation enforced, yeah, if in the legislation enforced there are changes regarding the way in which the price or the determination mechanism of the price is changed. So this is meaning if two parties in the supply contract are entering in a negotiation, they have a contract, in the end the elements of the contract, the content, the obligations, the object, the rights are very clear mentioned there. And during the execution, during the performance of this type of contract, legislation is entering into force and is changing this element, jeopardizing the interest and finally the private property of one of the parties, how is the supplier here. In a situation like this, we have also the civil code that is mentioning that you need a rebalancing to rebalance the situation in cases like this. In addition, also the provisions of the regulation 1854 that was established entered into force in 2022, especially for the situation like this, that the European institutions observe at the level of some legislation, some national legislation. It's also, in our opinion, automatically infringed, because this regulation mentioned that in cases where national legislation is coming and is changing situations like this in the contract, in a situation like this, according to this document, the full compensation of electricity suppliers, in a situation, as we said, for the supply of goods below the acquisition costs, then need to be established. If we are researching now the situation, the way how the contracts are performed in this moment from this perspective, we will observe that this case is not fulfilled also. So from this perspective, if the supplier could be obliged as a result of the legislative changes, yeah, to the clear price, or the determination of the price imposed like this, the question would be how can we continue with the executions of a contract like this, and how this would be in line with the principles of the European legislation, and not only this, as we explained also at the national level, legislation, also civil code, and also the specific legislation. So in the end, the question that remained for us and for this case for the suppliers would be, could we consider a contract like this a valid one, or let's say a contract that could be considered an effective, and also take into consideration that the supply agreement it is one of the most useful tools in the business, in energy business law and energy business law at the European level, as I said, based on the interconnection that we have in this domain, especially at the European level, practice for developing the acquisition, the transfer of this essential commodity and in the end for the transfer of private property, we consider that a situation like this, a case like this, cannot be accepted. And as we know, in this moment there are also initiatives from the European Commission for an action of infringement based on this aspect. So, respecting the European legislation, being always in compliance with this type of legislation, and going in the end to the basis of what is meaning these important tools that are the contract, and especially the supply contract here, it's important not only for the parties itself, but in our opinion it's important also for the entire environment, economical environment that is in a clear dependence on this aspect. And in the end, what I would like to highlight is the fact that this is a business in the end, and in cases where this type of suppliers are heavily impacted, will not be a surprise for us to see that they will decide to withdraw from a specific business area or from a specific country. Thank you. This is a short idea of the case.
Thank you so much. I know you presented a supply contract for energy from a European business law perspective, but I have a question.
Please.
More about curiosity. If Romania can become a supplier of energy for other countries in the region, or we are in need of energy from other places? Because
we are now we are talking about production. So to make a distinction here, the energy domain is composed by different segments. We have production, for electricity, gas. Production, it's based on power of the water. We have nuclear. We have wind farms. We have also based on carbon production. After the production, we have the transportation. We have Transgaz and Transelectrica, which are the companies that are transporting. So it's another segment. From here, we have distribution. This is another domain. Distribution is the main business, main activity where the specific companies are supporting with the grid, with the wires, and things like this, the transfer of these goods, of this commodity, electricity, gas. And in the end, at the end of this chain, we have the suppliers. Suppliers are the operators that are dealing in the end with the end customer, with the households, how we are saying, for the national persons, and also with business and administrative consumers. Related to your question, here we have the production. So from the production perspective, we are supporting our neighbors. We supported Moldova, as I remember last summer, Ukraine for sure, Bulgaria from time to time. But we had also had some issues based on the huge consumption that we have here in the summer. When you remember, we had this huge temperature. In that moment, we needed also help, and we were supported by the European interconnection channel from Hungary, as I remember, based on the western part. So depends on the weather, depends on the production in that moment, but generally we are a strong producer here. We are
self-sustained.
Self-sustained. Generally this is because we have also resources. We have good resources in comparison with other.
Thank you so much for your presentation.
Thank you so much.
And now, the last presentation of the day. Please bear with me. I won't keep you for long, I promise. I will be presenting a subject which is called Digital Transformation in Europe, Integrating Smart Contracts with CISG. Smart contracts is a dear theme for me. I actually have a love-hate relationship with this subject because it was the subject for my PhD thesis. And I would like to start by asking you, and I would like you to raise your hands, how many of the people in the audience have heard about smart contracts? Okay. Would you like to share with us what do you understand by a smart contract? Or in which context you have heard of this concept?
In relation to Bitcoins and all these?
Exactly. It usually relates to virtual currencies, indeed.
And in mining, because smart contracts should have, in a way, a trace in order to confirm that the contract took place electronically, and that trace in the digital area will not disappear. So you have, in a way, a source all the time. Like for Bitcoin, also the trace is only one with some identification, and then the smart contract also has a source. This is in a nutshell, let's say.
Indeed. It was a very good answer. Thank you for your input. If there is anyone else who would like to intervene. Yes, that was a very complex answer. Thank you so much for that. You see that when we're talking about smart contract, it relates to virtual coins, it relates to blockchain. All these concepts are pretty correlated, or they have a strong intertwine between them. But smart contracts per se, they usually are confused with contracts. It is actually a technical subject. It appeared in 2003, although it is coined from the 90s by a cryptographer, and he was also a lawyer. It was called Nick Szabo, and in the 90s it was this hype with the internet, .com area, and there were a lot of researchers who gave us a lot of science fiction scenarios in which you will have these automated contracts. And what do you know? 20 years later, we actually have the technology to put those ideas in place. However, although we do have the technology to automate some of the obligations in contracts, I'm referring here to the blockchain technology, we also need to address the problem if this is actually a viable solution in an economic context. So, can you help me please with the presentation? I have 4 slides. I promise I won't keep you for long.
Do you have it on a stick or
no, on email.
On email.
If not, it won't be a problem, but it was better to have visual support. Would that be
it will
possible?
take a few minutes in order to put it on the screen.
If we can do that while
Okay.
I start my presentation. So my presentation for today has 3 parts. I thought in the first part to present the definition, or to have, let's say, a common ground of what smart contract means. Then I wanted to link this subject with the CISG, which means the United Nations Convention of Contracts for the International Sales of Goods. When I did my PhD, I addressed the subject of smart contracts from a civilist point of view. So I wanted to see if these smart contracts are actually contracts from a Romanian point of view, from the Romanian civil code point of view. However, in this presentation, I wanted to see if this convention, the CISG, can apply to these smart contracts, and if smart contracts are or can be considered viable contracts under the CISG. So that is actually the third part. The first part is explaining what smart contracts are, and I'll come back to this subject in a minute. Then I will give an overview of the convention itself, and then I will try to link both of the subjects and see if they do apply to smart contracts. So when we're talking about smart contracts, jurists try as they might to define this concept as being a legal one and to give this computer codes a legal value. There are so many attempts in defining smart contracts, and we still don't have an unanimous definition of this concept, of this notion. So, but if we look up all the definitions proposed by scholars all over the world, and from some legislators were brave enough to come up with laws addressing this problem, you can see a red line. So the common denominator when addressing the problem of smart contracts is that they are not contracts, although they do have this denominator in their names. They're actually computer codes. And they're actually computer codes which have this innate logic of if-then. So they have a conditional logic within them. And people, in the beginning, they associated this type of the smart contract with a vending machine, meaning that you insert a coin and you receive something in return. the same happened with these smart contracts, which again, they're actually, in essence, they're only computer codes. But although they are computer codes, they're not just that. They might, in some cases, have a juridical effect. So they can be considered legally binding, and they can be considered contracts if they fulfill the requirement conditions from the contract law, meaning that there is an offer and the acceptance of that offer, and both of them combined, they become a contract. So, although smart contracts, they are not necessarily depending on a blockchain, they do, however, linked. They are, however, linked to the smart contract, to the blockchain technology, and they borrow from this technology all those characteristics that the blockchain has, which means the immutability, which means that once you have placed a smart contract on a blockchain, it cannot be altered. It will run exactly as it was written. It is transparent. They are transparent. Smart contracts are transparent, and they borrow this characteristic from the blockchain they run onto, which means that everybody can see the code, and if that code has a legal value and can be considered as valid offer and acceptance, then everyone can see through that code. They have this pseudo-anonymity. In order to be part of a blockchain and to have the possibility to conclude smart contracts, you need a private and a public key. This is why it's called pseudo-anonymity. That cannot be linked to a specific person, but you can, however, be identified. They also have these two very specific and important characteristic of self-execution and self-enforcement, which means this automatic nature of self-enforcing and self-executing. So, in order to make smart contracts a viable alternative for the traditional contracts, let's say, they have to be linked because they operate in this blind environment, which means they operate in on systems which are closed. They need to have a window to the outside world, and they gain this through oracles. Oracles are these data sources from the outside world, which feed the blockchain with information from outside world. And they make them more flexible. Once you put a smart contract on a blockchain, that is a fixed set of rules, so you cannot alter them. But in order to make it function, or to halt the execution, for example, if you see a bug in its code, you need these mechanisms, safe mechanisms, let's say, and it is advisable to have this link between the smart contract and an oracle. Now, I have said before that we should address the problem of what smart contracts are. So long story short, they are, again, they are computer programs, but these computer programs, which usually run on blockchain, they can have a legal value. And there are so many implementations of smart contracts, and they run actually on a spectrum. This is how they're seen. You can have at one end of the spectrum smart contracts which are entirely in code, and at the other end of the spectrum, you can find these legal contracts, so the traditional contracts as we know them in words as we understand them, which can be then translated, or which have a separate code that execute the obligations stated within the content of the contract. And in between those two extremes, we have this, they're called hybrid smart contracts, which means they have the code of the smart contract, but also words, as we understand. So it is a built-in smart contract code which run together with a contract, a traditional contract, let's say. So these are the three types of smart contract, meaning the first one is there are smart contracts which are expressed solely in code. The second category, smart contracts which are expressed both in code and in natural language, as we understand it, human understand it. And then we have smart contracts, which are a tool for automating a contract written in a natural. Yes, that's the presentation. Okay, thank you. So this is the three parts of the report. the definition, the 3 types of smart contracts, and examples, how can they be used in a commercial context. And I only addressed two examples, the one of supply chains and the peer-to-peer transaction. Although there are many implementations nowadays and many forms that the smart contract can take, we still don't have a killer app, something to give the tone, let's say, regarding the smart contracts and make them appealing to everybody. They're still in a very narrow area, and many people are afraid of the things they don't know or they don't understand. So it is this uncertainty regarding their legal validity, because then again, we have defined them as computer codes. How can computer codes be contracts, you may ask? And we will have to take each of the 3 types of smart contracts and analyze if they fit under the CISG, which states that in order to have a contract, you need to have an offer and an acceptance. And the offer has to have certain conditions. Yes, thank you. And the CISG states that to constitute an offer, a proposal should be sufficiently definite. Well, I will link this with the condition with the end of the presentation, so I will join the 2 of them. So, in order to constitute an offer, a proposal should be sufficiently defined. If we think of the mechanisms of forming a smart contract on a blockchain, how is it like? You actually puts an offer out there. So he actually makes an offer of a smart contract in which he states everything there is to know. So the goods, the price, the date, everything. As we've said before, the smart contracts actually looks like conditional clauses. If you pay a certain amount of money by a due time, you will receive something in return. But they have to be very specific. So the first criteria, the first condition is met for the smart contract in order to be considered a valid offer under the CISG. The second element, it says that the proposal should not only be sufficiently defined, but also it should indicate the intention to be bound. Well, when you put something online, on chain, when you put a smart contract on chain, you automatically accept that by triggering that smart contract, so by another person interacting with your smart contract, that contract will conclude automatically. Because it's put on a blockchain, it's immutable, so you cannot alter them. So indeed, you can infer from this context that by putting a smart contract on a blockchain, that person, the offerer, actually has the intention to be bound. So the second condition is again completed. We can state that this condition is valid. And the third condition for an offer to be valid, or for a proposal to be considered a valid offer, it states that it should be addressed to at least one person. And the convention said that if it is addressed to the public, it has to derive from it that it was actually the intention to constitute an offer. And we are coming back to the mechanism of forming a smart contract, meaning that you put something there, something on chain, a proposal for a smart contract. And although everyone can see it, because we've stated before that if you put something on a blockchain, it borrows the conditions from that blockchain. The blockchain is transparent, meaning that everyone can see it. So it's actually an offer made to the public. Everyone can see it. So if someone would like to accept that offer, it would interact with the smart contract. It will trigger an action in that blockchain, and the contract will be formed. So then again, the third condition is also met. Now, moving on to the second element, which is the acceptance of the offer made online. The convention said that in order to constitute an acceptance, the offeree statement or conduct should indicate assent to the offer. Well, if I transfer an amount of cryptocurrency to that smart contract, and that action actually triggers an action, isn't that a valid, or can we not conclude that the person who acted in this way actually had the intention to be bound, and it's actually an assent of the offer? Of course, the answer is yes. So we do have a valid offer. So this proposal meets all the requirements to be considered a valid offer. We do have an acceptance, and we need to address the last question, which means the offer is acceptance. It's not subject to any form requirements and may be proven with any means. And now if we look in the text of the convention, we'll see that this written form is a very broad notion. So even though the convention was adopted in 1980 and Romania ratified it in 1992, it still has a text when it refers that the contracts concluded by electronic means, referring to teletext, they're also valid. So even though the convention does not specifically address the problem of blockchain, because blockchain appeared in 2001, or I hope I'm not mistaken. Anyway, it appeared long before the convention was adopted. You can conclude contracts through this mechanism. So an offer, a valid offer and a valid acceptance can be made through a computer code. So the computer code can actually have a legal effect and can be considered offer, respectively acceptance, meaning that you can form validly a contract according to this law. So this is the conclusion of the article, that indeed a smart contract can be considered contract under the CISG. And moreover, or another argument to this, is that 4 months ago, we started having this model law on automated contracting. It has only 10 articles, and I extracted one of them, which is Article 7, that actually legally recognized the value of computer code being considered as being an offer, a valid offer and acceptance. And now we just the first one, which is of interest for us. It says that the contract shall not be denied validity or enforceability on the sole ground that the terms of the contract are contained in data messages in the form of computer code. So we're actually under this article, which is another argument in stating that yes, smart contracts can have legal effect, can have binding effect, can be considered contracts, and there's no doubt to that, especially now that we have this model law. Thank you so much. If you have questions, we can discuss it outside. We have a 10 minutes break, and we'll come back with a third panel. So if you have questions you'd like to address now or during the break.
I will
yes.
Just, we know that the smart contracts, one of the conditional characteristics for them is they are irreversible. How can we challenge with these things from the legal perspective, knowing that in our world, I can have an addendum, I can change sometimes between the parties, come back again to a negotiation
more flexibility.
We have more flexibility based on our, let's say, let's say classic way of working in legal. How do you see this?
I already presented one option, which is including an oracle in their code. So this possibility to halt from the exterior, but that will alter this self-executing nature, and which was proposed by those who sustain blockchain and who praises their characteristics. And another thing is that although you don't have an undo button, you can have another smart contract which has the opposite effects of the first one. So you actually you have to sign or you have to conclude a second smart contract which undoes the
you abolish it with another
exactly
act.
yes.
Be
You
like
fight it with another smart contract, let's
good.
say.
Thank you.
Other questions? No? Thank you so much. Not a bad
First of all, I want to present myself. My name is George. I'm a Bucharest lawyer, and also I'm an assistant researcher at the Faculty of Law. What I say, it has been a full day of interesting debates and another presentations and topics. And now we have the last panel, the panel in which we're going to talk about subjects like single market, competition, and European company law. Our first guest, our first speaker is Professor Nicola de Luca. Professor, a few words about Professor Nicola de Luca. Professor is a full professor at Vanvitelli University in the discipline of corporate law and business law, and an associate professor at Louis University in the discipline of European business law. Professor de Luca will present us a topic called Immovable Castles, Movable Companies, and the Real Seat Criterion in Troubles. When you are ready, Professor, you can start the presentation.
Thank you very much for the presentation. If you allow me, I will stand up and speak in front of the screen, so I have my slides available. Okay, so first of all, I have to thank for the kind invitation to this conference. Everything worked perfectly. We are perfectly on time, the plane was on time, the conference is on time, everything was perfect. So thank you very much, and I hope this is just the beginning of a future cooperation between me, my institutions, and this university. Just to explain the title, Immovable Castles, Movable Company, and the Real Seat Criterion in Troubles, I show you the castle of which I'm talking about. This is the Torcrescenza castle. It is a manor in the countryside near Rome. Very famous, at least in Italy, for movies being set in this castle, and for famous weddings. I don't know if you are accustomed with football players from the Italian league, but Francesco Totti was married in this castle. This is one of the reasons why this castle is famous. And that's the reason why this case, which is very serious, it's not about Totti, of course, came to the knowledge of the vast public, of the common public. But the case is on the ownership of the castle. And I will use next slide just to explain the facts which are relevant to the case. First of all, this castle was an asset to a former company, Agricola Torcrescenza, which was formed in a form which is peculiar to Italian law, which is SRL, società a responsabilità limitata. I think Romanian and Italian are so similar that I can speak Italian specific names and being understood. This company was then converted into a Luxembourgian limited company. I don't know why, because we have no explanation of the reason, but I think it's for tax purposes, because in Italy the earnings from castles, even if they're used through companies, they are very subject to taxation. Whilst I think the reason for the conversion, for the cross-border conversion, was that Luxembourg does not put any tax on the revenues of such castles being used for sets, for movies, and for weddings. So there was a big activity within this castle. In 2010, this company, Ste, the shareholders together, belonging to the family, having this castle in inheritance, appointed a sole director. This director was a Luxembourgian man, or woman, I'm not sure of that. But the problem is that the sole director didn't manage the company. It appointed another person to manage the company, because the company must be managed in Italy, not in Luxembourg. So he appointed, or she appointed, the general agent. This general agent, however, felt empowered with very big faculties, with very big powers to do anything he wanted. And he decided to start new companies under Italian law and could contribute in kind the castle to such new companies. This was thought not enough to put in a security possession, the castle. So the first company, the Ste, contributed it to another intermediate company, and the intermediate company put it, the castle, in another company. The other company is the one known for the case, Edil Work. And the shares to Edil Work were sold. So what Agricola Torquescenza had, and also after the conversion into Ste, disappeared. Because the only asset was this castle was moved, so the castle doesn't move, but the companies do, was moved to another company, and then to another company, and then the shares were sold, and so the castle disappeared. At this point, the other shareholders to Ste, so the original shareholders to Agricola Torquescenza, understood that something had happened with their property and sued the sole director and the general agent, who was the manager of the castle in the meantime, before the District Court of Rome, to have the transactions which led the castle not to be anymore part of the assets of Agricola Torquescenza being declared null and void, vis-à-vis in particular Edil Work, which was the last company owning this property. But the claim was dismissed, since the Court of Rome, which is not available, the decision, we can read from the Court of Appeal's decision that the Court of Rome deemed that these operations were done within the limits of the powers of the director and of the general agent. Then they appealed, they lodged an appeal in 2018 before the Courts of Appeal of Rome, and the Courts of Appeal upheld the decision. It changed the decision of the first instance court on the grounds that the general agent may not use such powers as to deprive the company of its only assets, such as happened in the case. So the case was brought. The castle is 10 million, 15 million euros, so it's worth fighting for it. The case was brought before the Court of Cassation, and the Court of Cassation, in particular, there is a big lawyer behind this this activity, a very famous one. He was member of the Constitutional Court in Italy, and the Court of Cassation asked a question. It was asked to the Court of Cassation, and then the Court of Cassation asked the question to the Court of Justice, whether Italian law or Luxembourgian law would rule these activities by the sole director or the general agent, because Ste was a Luxembourgian company, but the Court of Appeals in Rome applied to the case Italian law. So in 2022, the Court of Cassation stopped the proceedings and referred a preliminary ruling on this question to the Court of Justice, and then in 2024, earlier this year, the Court of Justice saw the case. How? The preliminary question was rephrased because the European Court of Justice thinks that the Court of Cassation didn't ask it properly to the court. The question is not whether or not a company in the course of an international conversion faces this problem. The problem is general. Whether or not a company which is established in Luxembourg but operates only in Italy faces or not this problem. And the problem is, do Articles 49 and 54, the founding article granting freedom of establishment throughout Europe for companies, preclude the legislation of a member state which provides generally for its own law, for national law to apply to the acts of management of a company established in another member state? I have to give this little background on Italian law, on Italian international private law. Italy adopts the incorporation criterion. As many other European countries, I think Romania does not. The Western tradition is to have the real seat at work, so I was thinking about it. But it says, generally, I adopt the incorporation theory, but in cases in which the company is only set up abroad but operates only in Italy, then for me it's a pseudo-foreign company, and I apply Italian law. So it's a kind of real seat when I am interested in applying real seat. And the question, so therefore, is this a limitation in the freedom of establishment to apply to a formally foreign company but not having any relation other than the registered office abroad, internal law, such as Italian law? This is the clear point that the Court of Justice makes. The location of the registered office for normative arbitrage, so for the possibility to choose another corporate law applicable to the company, is perfectly okay, and it's granted by the Treaty on the Functioning of the European Union. The location of the registered office does not require also the location of the real seat, and this was cleared up in cases of secondary establishments, such as central semi-empires, and principal establishment, primary establishments, such as in Poland. Polish law is, I think, similar to the other Western traditions, Eastern traditions, sorry. The location, you can ascertain in some cases that placing the registered office somewhere is done only for abusing of the right, but you have to prove it. And it's not enough to say, since you want to apply another corporate law to the company, then this is an abuse. Applying another corporate law to a company is not an abuse in itself. It could be only in cases of insolvency. In cases of insolvency, there is a tradition which says applying another corporate law only because the company is insolvent is an abuse, but generally it is not. So you can have reaction to abuses provided that they are adequate to the abuse to which you are reacting, and this requires to perform the so-called Gebhardt test, which says the measure is proportional, it does not reach other objectives than the ones that were thought to be reached, and so on. This decision is quite in line with precedent decisions, but we have to consider that maybe it may be discussed whether or not, and if it's your tradition, it's a point which involves you so much. If it's still valid, this sentence that was made in Daily Mail. Daily Mail says the treaty places on the same footing all the connecting factors, so all the theories which go around with connecting factors. Registered office, central administration, principal place of business. You can ascertain the nationality of a company based on any of these factors. But is it still valid? can we really say that for the European Union, registered office, central place of business or administration are really the same after all these decisions being taken? I think that if we go from Übersetzung to Edil Work, we will see that the Real Seat Criterion is really in troubles and it cannot work anymore with the European principles on freedom of establishment. Übersetzung was the first decision connecting a Dutch company operating only in Germany, so it's a pseudo-foreign, but it was not pseudo-foreign at the time of constitution, since Übersetzung was really formed by and between two Dutch nationals who had a property in Germany. They wanted to develop a project, a construction project in Germany. Then they sold the shares of this company to German nationals, and the German nationals started to manage this company only in Germany. So the connecting factor faded, the registered office. Still, the Court of Justice said it is not possible to understand this situation as a situation in which only for the applicability of real seat theory, the company which has its legal personality in Holland loses its legal personality in Germany only because Germany applies the real seat theory. And the consequence is that you have to recognize the existence of this company, Übersetzung, in Germany. It was a question of capability to bring actions in the specific case. And as the Court of Justice does not decide cases, but it only gives a way for national courts to decide, the BGH decided the case saying, okay, it is not a Dutch company, it is a German company, it is an existent German company, but it's a de facto one, a GbR, Gesellschaft Bürgerlichem Recht. And German law does apply. And this is exactly the problem that was put in Edil Work. Could this decision still keep its principles? The other point is, after some years, this is 99 case, this is 2000 case, centrist said the register in Denmark cannot refuse registration to a company even if it's clear that the company has been set up in the UK only for granting these people, Danish nationals, the application of UK law, because normative arbitrage is permitted. And it said, it added something important. Even if you recognize that it's a letterbox company, it has the letterbox and that's all. In England, you have to recognize that it's a UK entity. The same was done also for Empire Art. In Holland, they passed a law after the decision in Centrus by saying, okay, we have to recognize all companies being set up abroad, in particular in the UK, but we want them to be similar as national entities, in particular for what is concerned legal capital requirements, protection of creditors, and so on. And the European Court of Justice again said, no, this goes beyond your function. You cannot oblige English companies to have capital requirements as Dutch companies, because maybe there are other ways in England to protect creditors. Trust that the other national regulation of companies, because if they work in England, they will work also in Holland, since we have mutual recognition of this system. The last part is, you cannot even oblige companies being set up somewhere else to receive parts of your national legislation. This was said in Edil Work. So I think after Edil Work, the Real Seat Criterion is no longer to be considered on the same footing of the incorporation criterion. Maybe it still works between countries that both apply the Real Seat Criterion, but it doesn't survive in cases where a company moves from one incorporation theory state to a real seat or vice versa. And this is, I think, granted by a piece of legislation, not decision of the European Court of Justice, a piece of legislation in the European Union. The definition of cross-border conversion, which was presented in the new directive of 2019, the 21 of 2019, it says a cross-border conversion occurs when a company transfers at least the registered office abroad. And if it is at least, we can count all the cases. From Poland to Luxembourg, at least. It means forward. You can keep the real activity in Poland and transfer just the registered office to Luxembourg. But you can do also vice versa. A Luxembourgian company, a Cartesio case. An Italian company being grounded in Italy, only transferring to Hungary, which is similar as Romania, the registered office, it becomes Hungarian. It becomes Romanian. And Hungary or Romania cannot say, under my laws, you have to place also the real seat. No, because it's at least. And if you can do it in a straight way, you can do it also reverse way. So exactly the case that was presented in Cartesio. Cartesio was refused the possibility to maintain the Hungarian nationality whilst moving the real activity to Italy, because they said, in Hungary we do adopt the real seat theory, and under the real seat theory you can go everywhere, but you have to go with your real activity and with your registered office. Nowadays, how would it be possible? If it's possible to move the real seat, to keep the real seat and move the registered office to Hungary, it is also possible to move the real seat from Hungary to Italy and to keep the registered office in Hungary to maintain the Hungarian nationality. So I think this is the conclusion that we have to take after this piece of legislation and after Edil Work as well. There are, of course, points in which maybe state legislation still has the room to prevail. I think these are the overriding mandatory provisions which Edil Work also contemplates. It says you can do something to apply your law to foreign entities only provided that something happens which relates, which interests third parties, thus creditor or workers, or minority shareholders. The case, the Edil Work case, was a case in which the minority shareholders were harmed because the decision to sell the entire assets of a company in quite all European legislation is not decided by directors, nor it's decided by general agents. It is decided by the general meeting because it causes the company not to pursue its objects anymore. If you don't have the castle, what is still your task? What can you do? So generally, this rule is intended as putting on the competence of the general meeting the decision. And maybe if it should be decided under Italian law, at some point Italian courts would have said, okay, we apply this overriding mandatory provision of our law because it's a point in which minority shareholders are so harmed that we cannot allow foreign law to be applied. Reality is that it's not necessary to apply Italian law because also Luxembourgian law provides for this kind of protection of minority shareholders. So the outcome of this big case, of this big decision, is that however Italian or Luxembourgian law the conclusion is no director is entitled to sell the assets of the family without prior consent of the other shareholders. Thank you very much for the
Thank you, Mr. De Luca, for your very interesting and attractive presentation. If anyone from the room has any questions about the presentation. Okay.
Just one moment,
okay.
because we have a special guest that arrived today at our conference, Mr. Stefan Hindenhan. He's an expert in European Union law and also in German public law, and he's also executive director to the Service Institute in Berlin. Professor, would you like to greet the audience? I know you will be soon visiting Professor to Assay.
Thank you so much for this very warm welcome. I didn't mean to interrupt this beautiful seminar because I was just listening to you, and it was fantastic. It also, I mean, having done EU law, but from a public law perspective, this is always interesting to hear private law, especially in company law. Thanks so much for having me. Very much looking forward to our collaboration. But the stars here are sitting here, so I'm just being quiet again. Thank you so much.
Okay. Thank you. We'll go further with our next speaker. The next speaker is Mr. Dan Pascu. Few words about Mr. Dan Pascu. He is the Vice President of the Competition Council of Romania, where he supervises and coordinates complex investigation and contributes to the formation of competition policies. Also, visiting Professor Dan Pascu is associated at our Faculty of Law. When you are ready, you can, Mr. Professor, you can start your presentation.
Thank you very much for having me. I'm going to depart with my modest presentation from the technicalities of law. Competition law, I'm a competition practitioner, is very technical, so I tried to lift the discussion or the level up to the academic side of the issue of competition interlinked with democracy. I suppose our dear Professor Nettesheim would be interested in such a topic, public law and democracy. I have to excuse myself, I'm going to read. Normally I speak freely, but I delayed, I procrastinated the drafting of my paper so long that I was not able to learn any more the content. So even it is going to be maybe a little bit boring, I'm going to bore you with my ideas about competition law and democracy. It's as I'm trying to put myself in the right light. I didn't hear anything in Romania since I arrived back from Germany about this topic. I don't think there was any paper drafted about the relation between between competition law and democracy. Although this topic is widely discussed in Western Europe and in the United States of America, while the effects of democracy on competition are quite obviously as a consequence of the rule of law governing democratic systems, non-discrimination, ensuring a level playing field for market participants, economic liberty, protection of rights, and the independence of the judiciary, the role of competition in ensuring and fostering democracy can sometimes go unnoticed or be underestimated. Since time wouldn't allow to give a detailed presentation, I have decided to refer a few notable figures or groups who will help me, I hope, outline this topic in a way that is as clear, as understandable as possible for you. To do this, I will refer to an American senator, a Jewish judge, a Turkish-American economist, the Nazi regime, some German scholars, and I will touch also briefly on a few hipsters. So the modern story of competition law and competition law enforcement starts in the United States of America. It couldn't be otherwise. There, in the second half of the 19th century, the owners of large competing enterprises transferred the management of leadership of these businesses to a person they trusted. This is how trusts emerged. We basically, competition practitioners, are fighting trusts. It's counterintuitive because trust is a rather positive word. The combination of undertakings, these kind of combination of undertakings were actually cartels, by means of which companies acted as a single entity, just like a monopolist. They began to suppress all forms of competition, increasing the political influence of their owners. If the concerted powers of this combination are entrusted to a single man, it is a kingly prerogative, inconsistent with our form of government, and should be subject to the strong resistance of the state and national authorities. These were the words of the American Senator Sherman, stated during the parliamentary debates prior to the adoption of the Competition Law 1890. The Sherman Act is the first modern antitrust law. He goes further. If anything is wrong, this is wrong. If we will endure a king as a political, if we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any of the necessaries of life. If we would not submit to an emperor, we should not submit to an autocrat of trade with power to prevent competition and to fix the price of any commodity. The first modern antitrust law was enacted to protect economic freedom and competition as cornerstones of democracy. A few years later, in the early 20th century, we have a progressive movement in the United States of America under the presidency of Woodrow Wilson, and the leader of this movement was a judge named Louis Brandeis, appointed by President Wilson in 1916 as a justice at the Supreme Court of the USA. Louis Brandeis was the first ever designated Jewish judge in that position. Both Wilson and Brandeis were strong advocates of progressive reforms. Brandeis was renowned for his efforts to combat monopolies and promote social justice by means of competition law, which resonated with Wilson's New Freedom agenda that aimed to increase economic competition and to reduce corporate influence. Brandeis was widely respected as a brilliant lawyer and legal thinker. His work, particularly his critiques of concentrated corporate power and advocacy for transparency in public affairs, made him a leading figure in the progressive movement. He supported the idea that the law should evolve with the social changes, and that courts should consider the social context of legal issues. With respect to competition, which represented one of the most important aspects of his activity as a lawyer and judge, Brandeis was deeply concerned about the economic dominance and political influence of trusts and monopolies. He considered the latter inherently dangerous not only to the economy, but also to democracy. One of his most famous quotes is, "We may have democracy, or we may have wealth concentrated in the hands of a few, but we can't have both." On the other side of the Atlantic, the European approach to competition law has been shaped by the ordo-liberal tradition, particularly in post-war Germany. Ordo-liberalism emerged as a response to the economic and political mostly a response to the economic and political turmoil of the time, especially the economic and political collapse that led to the rise of the Nazi regime. A compelling connection between monopoly power and the rise of fascism in Nazi Germany was drawn by academic researchers. The concentration of economic power in the hands of a few large corporations facilitated the Nazi regime's authoritarian control. The lack of competitive markets in pre-war Germany allowed the regime to manipulate economic resources and suppress opposition, illustrating the dangers of monopolies in undermining democratic processes. These events underscore the need for a framework that balanced free markets with strong and effective state oversight to prevent economic instability and the concentration of power. Although liberal competition law theory suggests democracy as a key non-economic factor that is essential in curtailing economic power from corrupting broader democratic processes, it recognizes the link between economic freedom and political freedom, further arguing that dispersed economic power is crucial for a functioning democracy. The principles of ordoliberalism are now embedded in the economic framework of the European Union. A theoretical and empirical foundation for understanding the interdependence of economic systems and democratic institutions is provided by the work of Daron Acemoglu, I suppose that's the way the name is.
Acemoglu, as far as I'm concerned.
A Turkish-American economist, this year's receiver of the Nobel Prize in economics. While Acemoglu, Daron, does not always explicitly frame his arguments in terms of competition law, I had the pleasure to hear a conference of him at the OECD in Paris. It's really great.
I read papers of him.
His emphasis on the dangers of concentrated power, whether economic or political, aligns with the broader idea that fostering economic competition is essential for maintaining a healthy democracy. When economic systems allow for open competition and prevent the concentration of power in a few hands, it supports the stability of democratic systems. He also underlines that economic competition limits the ability of elites or monopolists to dominate markets and to use their wealth to undermine democratic institutions. As I read my paper before half an hour ago or 1 hour ago, I realized I forgot one very trendy word within the European Union, and that would be de-oligarchization. That's the situation in Georgia, if you think. Mr. Ivanishvili owns the production capacities which represent 70% of Georgia's GDP. So he actually owns the country. And if we think about concentrating the power in a few hands, we could also talk about the so-called Russian Republic, which is owned by a few oligarchs led by the Tsar. So, as Daron Acemoglu, also in the tradition of the American progressive, he is in the tradition of the American progressive era, which I've mentioned at the beginning with Louis Brandeis. As Mr. Acemoglu is a new wave of thinking in antitrust law and policy that critiques traditional antitrust frameworks as too narrowly focused on consumer welfare. We enforce competition law, that's the main goal, to ensure consumer welfare. The critique is that we should concentrate on broader social, political, and environmental concerns. Described dismissively as hipster antitrust, this new wave argues that the consumer welfare standard is too limited and fails to address other harms, such as concentration of economic and political power, reduced innovation, the impact on workers or small businesses, or sustainability issues. Dismissively hipster antitrust, they are also known as new Brandesians. Hipster antitrust has sparked significant debate in legal, academic, and policy-making circles, prompting renewed scrutiny of how antitrust law is applied and whether it should address broader societal concerns. So as a conclusion, The interplay between competition law and democracy underlines the paramount role of antitrust principles in maintaining not only economic fairness, but also political stability. From historical movements like the creation of trusts to the evolution of frameworks like ordoliberalism and the modern hipster antitrust I just mentioned, the common thread is the recognition that unchecked market concentration threatens both economic freedom and democratic institutions. This progression reflects an enduring truth. Competition is not just an economic mechanism, but a cornerstone of a just society. Ensuring fair markets prevents the concentration of power, fosters innovation, and supports democratic accountability. Whether through the structural focus of ordoliberalism or nuanced critiques of the new progressive waves, the message is clear. Healthy competition is a fundamental guarantor of liberty and democracy in an ever-evolving economic landscape. Thank you.
Thank you, Professor Dan Pascu, for your presentation. And if there are some questions from the room about the presentation, please.
Sorry, just out of curiosity, I was yesterday in a conference in Brussels where a Finnish MP was a competition conference of all places, where I ended up, and a quite known Finnish MP, European Parliament, member of European Parliament, advocated that we shall, stop merger control until we have finally European champions, which can compete wonderfully with the Googles of this world. Maybe not so much against Google, but more Chinese corporations.
Alstom and Siemens, for example.
So, exactly. So I had this irritation feeling, but how would you reply to this? There seems to be really, also among all the competition lawyers in the room, nobody was really standing up and saying we need to basically uphold the flag of ordoliberalism. It was like, well, it's a trend. So where do you see competition?
No, that's my personal opinion, but I think it matches also the opinion of my institution and of the European Commission also. And the main question is, do we need elephants in the room? I think we don't need them. We have the experience with the big tech companies. I have to think now about Yanis Varoufakis, who talks about neo-digital feudalism. We have them. They did a lot of harm. Yesterday, Facebook was fined 800 million by the European Commission. Google was fined by the European Commission in a total amount of $8 billion for abuse of dominance. They can do a lot of harm. I don't know if we went as far in the European Union that we drafted and adopted the DMA, Digital Markets Act, so that we, public authorities, do not have to enforce and investigate breaches of competition law, but there are some sort of ex-ante prohibitions if they collude with this ex-ante prohibitions. There are automatically sanctions. It's, I think, the only way to put the beasts again on the leash, because they have the means, they have the financial power. So I think it is a safer environment in Europe as it is without having these big actors mainly in the digital sector, because the economy moves towards the digital sector, and that's a proposition. Think only about the impact of X in the elections of the United States of America. Do we need something like that in Europe? I don't know. It's a rhetorical question. But thank you, Stefan, for your question.
Okay, any questions? Okay, we'll go forward with our next speaker. I pleasure to invite Modelina Cotruz. Modelina Cotruz is a PhD candidate and also is a lawyer in the Bucharest Bar, specialized in international tax law. She will present a very technical topic called Challenges of Permanent Establishment Created by Non-Residents in Romania. When you are ready, Modelina, you can start the presentation.
Thank you very much, George. So, Professor de Luca mentioned taxation, so now we are talking about the international taxation. And my topic today would be about permanent establishment challenges of non-residents in Romania, and with a specific focus on cross-border remote working. So permanent establishment is actually, let's say, a registration of a non-resident company, but from a tax perspective, we can use it for you to understand the concepts better, to assimilate it with a branch. But this permanent establishment does not have a legal registration, just a tax registration. So my topic is about cross-border. So we have an employee that works from a state for another company that is resident in another state. So we need to have the cross-border element. And what is actually the meaning of cross-border? Because in doctrine there are many terms used. So distance work, home working, e-working, teleworking, telecommuting, but actually in the end all are defining the same thing. This situation that the employee is working from another state, and I introduced here a definition that actually is provided by OECD. And in taxation, we keep an eye on the developments at the level of OECD, and also the developments of the level of EU. They keep an eye on what OECD is doing or regulating or recommending at the level of OECD. So a teleworker is defined as an employee working physically from a jurisdiction, so we can have an employee in Romania, and where the employee is also a tax resident, and he is working for a company that is resident in another jurisdiction, let's say Hungary, Italy, doesn't matter, and it's connected through internet and needs a laptop or phone to perform its activities. And at the level of OECD, the challenges, the points of discussion, so what would be actually the problems in the future in such a situation for such an employee working in another state than where the employer is located. So we have the issue of the location where the employee is performing its activity, either in its own home or in another location, like these new co-working spaces or in a cafe. How long the work will be performed, is it going to be permanent or temporary, and how regular or occasional it will be, the work done from another state. The idea of my research is that remote working, in order to understand the rules, how they are developed in the international tax arena, is important to take the example of an employee that is working permanently from home. So he will not go in the other state where the employer has offices available maybe, but he will not go. He will definitely work from home. And this is an example that is coming, of course, from the experience of COVID. So this is possible. It's not a hypothetical example. And because we are at a conference about EU developments, at the level of EU, the issue of remote working is becoming very important, so it is on the agenda. In the first half of the year, Belgium was at the presidency, And they formed an informal task force that were dealing with cross-border remote working. And indeed, the discussions have not resulted in a binding arrangement. And there were 20 representatives of EU member states that participated. So many countries consider this an important issue. And they issued some documents, but they are not official yet. And they focus, of course, on the taxation of salaries, and also where, if a fee will be created by such a development. Because this is actually, I mean, these two issues are becoming important. Why? Because according to the international tax rules, employment income is taxable where the activity is performed, and based on the traditional rules, the employment activity was performed in the state where the employer was located. So this was not taken into consideration that an employee would actually work from its own state. So this is one situation that the taxation of employment income might change, and also the risk that an employee may create for the company for which the employee is performing, may create an exposure, a tax exposure, meaning this permanent establishment, that actually that employer will have a small company, let's call it like this, a branch in Romania, in our example. So employer is resident in Hungary, and due to the fact that the employee is resident in Romania and performs activity from Romania on a continuous basis, then there is a risk that a PE will be created by this employee, and through this PE, a tax will be payable actually in Romania due to its activity. And of course, this is a risk that for the employer or for the multinationals or the companies that have such employees working from abroad, is a risk that they need to take it into consideration. And in present, there are discussions and research done, and of course this is how I ended up with this topic, to do a lot of research, that in the tax treaties concluded by Romania and by many states, so there are tax agreements, international tax agreements, to avoid double taxation. And these tax agreements, they are concluded following some two models. One model proposed by OECD, and another model proposed by UN. And there are, in these treaties, several types of PEs that may be created by companies in another state, or in my case, by the employees. And relevant for our discussion of today, there are three types of PEs. I will not tell you too many things theoretically, so we will not go there. We will just stay to the practical aspects. So we have the basic rule PE, and in case of an employee, so in my example, the employee located in Romania at home using its own laptop and doing activity performing activity for the employer located in Hungary. And the idea is that Hungarian employer might be subject to corporate income tax in Romania due to the presence of this employee performing activity in Romania. And such a basic rule PE may be created, but there are certain criteria that should be fulfilled in order by an employee to be considered that creates a basic rule PE. And on this criteria, very important is that there is a fixed place, meaning that a home office can be a fixed place, has an address, and it's used for performing activity for a longer time, over 6 months, so it is. But the most debatable element of such type of PE is the place to be at the disposal, meaning the employer, the Hungarian employer, to have access to the home office of the home of the employee. And this is difficult to assess because usually the employers do not have access at the home, in the house of an employee. So there are jurisdictions also, for example, like Austria, they are not testing the home office of the employee, but they are testing the laptop. And if an employee receives the laptop and uses it for performing the activity, then such a basic PE exists and will be created. So the Hungarian company can be subject to tax based on Austrian approach. In the doctrine, it is said that if we take this approach, we will end up in practice with so many PEs created by by employers that what income should be allocated to such PE in order to be subject to tax. If we consider that such a company, the Hungarian company, will be subject to corporate taxation, on what income? On the salary received by the employee? On what? It should be some allocation key in order to make sense, this presence of a PE to make sense. So in doctrine, it is considered that there are too many micro PEs, so there is a huge risk to create a micro PE with a lot of compliance, so it will not make any sense. But OECD is focused on this type of PE, and they are now working on changing and making more clear these rules. Unfortunately, it may be that they will stick to this PE type. Another PE type is the agency PE, meaning that such a PE may be created in case an employee has the authority to conclude contracts on the name of the company. So the Romanian employee will have the authority to represent the Hungarian company in front of clients in Romania and to conclude contracts with the clients in Romania. Such type of PE may be created indeed, but it is only targeting the sales representative employees. So it is not a type of PE that applies to all the employees. So while I was doing my research, I concluded that the agency PE will not be the solution if we move forward from what OECD is doing now and what EU is actually waiting, because at the level of EU they are waiting for the developments that are taking place at the level of OECD. And in my research, the biggest surprise was that there is a type of PE, the service PE, that is promoted by UN, and OECD is disagreeing actually with UN, and OECD does not provide it in the model promoted, but in the commentaries. And this type of service PE brings many advantages to the new type of performing activity in a remote working environment. So in my research, I concluded that this type will bring so many advantages to the rules that they are now looking for, and to change and to adapt the rules to the new way of doing business and performing activity. And the relevance of this service, or why I am saying that this type of PE is important, because the employees are performing also internal operations for a company. So those types of activities will be eliminated. So in this type of service PE, only the contracts that are concluded with clients will actually matter. And in this way, the issue of creating too many micro PEs, where only the salaries are allocated to this PE to be subject to corporate taxation, will be eliminated. So in a way, indeed, the added value that the employees are bringing to the company will be subject to taxation in case of cross-border remote working. And what is the relevance from a Romanian perspective? We have, I checked all the text treaties concluded by Romania with other states. We have a total of 89 treaties, and we have included in our text treaties in 31 a provision regarding service fee. But to activate a provision that is included in a text treaty, it needs actually to be also included in our text code. And we have here a problem, an issue, because in our current form of PE included in the text code, we don't have this type of service fee mentioned. And it means that all the text treaties, 31, will not be applicable in Romania if in the future the solution to tax cross-border remote working will apply based on a service fee. Because I'm talking about remote working in this presentation. Nevertheless, if there is other situation and services performed normally, this conclusion will still stay. So no matter that countries negotiated with Romania this service fee, Romania cannot enforce it because we don't have it in the text code. So this is my presentation of today. Thank you very much. And if you have any questions or, I don't know, curiosities, let me know.
Thank you to Madalina for your presentation. Like I said at the beginning, your subject, your topic was very, very technical and so interesting, I said. Well, because Madalina was the last presentation of this panel, I propose to close the proceeding of this panel, concluding that we had very, very interesting presentations. Finally, I want to address special thanks first to the whole speaker and for the whole presentation of this day, and second to the organizing committee, especially to the Professor Ioana-Dumitru, which is the Dean of the Faculty of Law, and at the same time to Mrs. Andreea Stănciulescu for all her involvement in organizing this edition. Thank you.
Thank you, George. We're a few now at the end, but still. Thank you, the esteemed guests that presented in this last session, but also all the others who presented during the day. Patrick, anyway, was the one starting, and now we ended. The third edition, again, for the first time with more people present, but still hybrid. I want to thank everybody online because we have also students and professionals who actually followed us on the channels, either the channels of our faculty, the YouTube channel that we have, and Facebook, but also I have to indicate that this conference, this event was broadcasted by three important channels. One is in the legal world essay of Walter's Kluber that you well know. So the ones who are anyway in minds of this platform will have the chance to follow us also there. And also DC News, anyway, however you want, which is actually a platform offered for the public. So thank you all the participants. Hopefully we'll see each other all and others next editions. During the day, as I told you, we have this all these activities and all these projects that we'll pursue in the future. And why not? We'll have the chance to meet again in different activities of different projects in the European business law area of our new faculty. I have to thank the main partner, the Romanian Society of Business Law, of whom we had some representatives today. The the center, yeah, very young center with Andrea here, and I want to thank her for the her activity in organizing this conference, but also in setting up the center. And of course the other partners that we have, BEC, University Juridic, and others. Thank you all, and yes, Georgia was the one closing the, let's say, the scientific part. I'm closing down some of the works of this conference, and we'll keep in touch, and for sure we'll see each other in, as I said, in other activities. Thank you all.
Yeah.